Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Here, all persons having business with the appellate will join here. In the attendance, you shall be heard. Please be seated.
Good afternoon, everyone. So, welcome to the Appellate Division, First Department. Oral arguments for today, October 22. I see familiar faces, so you all are regulars. You know what the procedures are. Please only ask for the time that you actually need in order to get out the salient points of your arguments. We are fully familiar with your briefs and with the arguments. People v. Alexander Carno. Five, 5. Clark v. New York City Transit Authority. I'm sorry, you're the appellant? And we have a respondent? Fine. 525. Matter of Jahar versus Sharon W. That matter is submitted. Kim v. Francis. 525. I'm sorry, there are two. I apologize.
No, another.
So I have Kim who's the second respondent? 5251. Rockaway Triumph versus Concept Salon.
Appellant 4 minutes. Into. Your Honor, time 10 minutes.
Certainly. 415. Kalar versus PS&G, Long Island.
For appellate, 5 and 2, please, Your Honor. Respondent request 5, Your Honor. Third party defendant responded 5 minutes, please, Your Honor.
5255. People v. Malik Branch, the appellant. That matter is submitted. Second matter, People v. Malik Branch. That matter is submitted. Martinez versus Partnership 92.
Appellant seeks 5 and 2, Your Honor. Good afternoon. Third party defendant, appellant request 5 and 2.
Okay, so you represent whom?
Third party defendant, Fisher.
Fisher. You're requesting 5 and 2. The next respondent? Next.
Respondent, defendant, third party plaintiff,
Is that it? 525254. Stuyvesant Town versus New York State Division of Housing. Justice Scarpula is recused on that matter. If there is a tie, another judge will be vouched in.
Appellant request 8 and 2.
626. Atlantic Center versus the City of New York.
For the appellant 9 and 3, Your Honor.
626. Lauren v. Hotel Pennsylvania.
For the appellant 3 and 1.
For the respondent, 3 minutes.
313. AC 31 LLC versus Fowler.
Appellant, 3 and 1.
Respondent 5.
313. Gamma v. 2001 Story Tower.
Defendant appellant is requesting 2 minutes.
Respondent 1 moment, 1 minute, Your Honor.
So you did not request any argument time. So it should be submitted then?
I can still request 2 minutes. I won't use it all.
No, you won't. Doxiadis versus Triborough Bridge.
Respondent 5 minutes.
525. People v. Donald Douglas. 424. Allen v. Allen.
Appellant 4-2, please. Respondent 5, please.
424. Quick Park versus Bridgewater Operating is submitted. Catwalder versus Mod Champagne is submitted. First matter for argument is People v. Alexander Carno. You may proceed.
Thank you. Good afternoon, Your Honors, and may it please the Court. Jane Merrill for Appellant Alexander Carno. I'm planning to address point 2 of my brief. The problem here was not that finding Mr. Carno registrable impermissibly gave retroactive effect to the SORA statute. That's a practice that the Court of Appeals has explicitly and repeatedly approved. Rather, in finding Mr. Carno registrable, the SORA court gave retroactive effect to the substantive penal law statutes, a practice which the Court of Appeals has never approved. Mr. Carno's conduct was not prohibited under either of the proffered statutes at the time it occurred. Therefore, it was error for the SORA court to apply the statutes in effect at the time of the hearing to find him registrable.
So your argument is that what statute should have been the effective statute?
Yes, Your Honor.
At the time of the
effective statute should have been the one that was in place at the time of Mr. Carno's conduct. That statute prohibited the conduct only for complainants under the age of 16. Mr. Carno's conduct involved complainants aged 16 and 17, and so did not fall within the bounds of that statute as it existed at the time of his hearing. It was error to apply the law as it existed at the time of the SORA hearing, not because that violated the ex post facto clause. Respondent and I absolutely agree on that point, and that the ex post facto clause has no application to this case. But where respondent contends that that concludes the analysis, it really only scratches the surface. Even where the application of a statute does not violate the ex post facto clause, it can still run afoul of the presumption against retroactivity. The strong presumption against retroactivity is only overcome where the legislative history of a statute supports that that statute or amendment was both remedial and intended.
So the statute talks about the essential elements provision it uses present tense. So given the fact that it uses a present tense as opposed to using a past tense, would we not then interpret it as present tense?
So we're dealing here with two separate statutory schemes here. The SORA statute, as Your Honor notices, uses the present tense. There is case law from the Second Circuit that says the mere present tense of a verb does not resolve.
Is that the D'Amico case you're referring to?
It's not the D'Amico case. I'm happy to address the D'Amico case.
Well, because the D'Amico case actually goes against your argument.
It does,
because
Your
it
Honor.
specifically states that where you're talking about the present tense, that means that this is the statute, the section of the statute which would apply.
The full holding of D'Amico on this point was that it characterized the registrant's argument as based on the prohibition against ex post facto laws and says that it is without merit. It then cites to 3 cases, none of which stand for that proposition. Those 3 cases, in each of those, the registrant accepts the fact that the SORA statute had some retroactive effect based on the text of the statute.
Counsel, though, but I mean, no matter how you dress it up, and no matter how you sort of say it isn't so, aren't you saying that we court are applying a law the SORA statute to a crime that wasn't a crime at the time? And isn't that like exactly ex post facto? No matter what you call it, you can call it green jelly. But that's the argument you're making, right?
I'm not, Your Honor. All of the arguments about the ex post facto law argue that the civil statute was so punitive as to constitute a violation of the ex post facto law. I'm not saying that
do you have any case that addresses this issue in any other way than what would normally be the way that you address it, which is through ex post facto?
I would submit that this is a novel issue that has
It's not really novel, though, because it has been addressed in a number of other cases through the lens of ex post facto, right?
Those cases all deal with the retroactivity of the SORA statute, not the underlying penal statute. The Court of Appeals has held time and time again that retroactive application of the SORA statute is just fine But that's really not what we're dealing with here. What was given retroactive application here was the substantive penal law statutes that works within SORA. And that does not have a punitive effect, so does not violate the
What
ex
is
post-
that to me? I don't understand what the difference is. That to me is a difference without a distinction without a difference, right?
I'm not sure that it is, if I may respond.
Ask the people.
May I
Yes.
respond, Your Honor? Thank you. In most cases, when the SORA statute is given retroactive effect, it applies to a whole class of registrants, all of whom are treated equally. This doesn't do that because no one else at the time of Mr. Carno's conduct could have been convicted under this penal law statute.
But we're not talking about conviction. What we're talking about is just mere registration here. So why wouldn't we apply the current version of the penal law?
That's correct, Your Honor.
And why would it matter? I mean, I don't know. There could be other potential registrants who would fall under the same category. So I'm not really understanding that argument.
Why this sets Mr. Carno in a class by himself, Your Honor?
Because I'm not really sure that it does set him in a class by himself, and I'm not even sure that that would be relevant in terms of the retroactivity or ex post facto portion of the law. That's what I'm not understanding.
That's correct. The retroactivity analysis has no discretion. There's no weighing of the equities in this. It's purely a question of statutory interpretation. And because of that, the really only two factors that are analyzed under that is whether the law is remedial and there's evidence of intent for it to be applied retroactively. And that simply doesn't exist in the penal law statutes that we are discussing.
Ellen, did you have a question? Thank you. You have time on rebuttal.
Thank you.
Good afternoon, Your Honors. Michael Tarburton for the people. Your Honor, I believe that your point is dispositive of this case. No one is trying to convict the defendant of these penal law crimes or imprison him for them. The retroactivity analysis has nothing to do with the penal law statutes. It has to do with SORA and the legislative intent in SORA. And of course, SORA from the beginning was a retroactively applicable statute, and that's been held many times.
Well, yeah, go ahead.
But isn't it underpinned on the current version of the penal law? And I guess the argument is that shouldn't it be based on the prior version as opposed to the current version?
No, Your Honor. For the very reason that the analysis is required is to compare the defendant's foreign conviction and compare the essential elements of that with the penal law in New York State as it is now. It's in present tense. The fact that that wasn't the penal law at the time, again, it's not the penal law that we're trying to apply to the defendant. It's the registration requirement. No one's trying to convict him of this crime. In addition, Your Honors, one thing that might make this a little clearer is that as to the barbarian prostitution, the second-degree offense, that was admitted after the defendant committed his crime, which would have brought him into it after the fact. At the same time, I'm sorry, I wanted to address the other crime, sex offense of a child. When the legislature enacted that offense, they also amended SORA to include that offense and require registration for it. So again, they intended that this offense be retroactively applied to require registration for defendants who either had committed that offense or whose foreign offenses contain the essential elements of it. So again, it's retroactive. The retroactivity analysis applies to SORA and not to the penal law offense. Thank you, Your Honors.
Thank you.
Thank you, Your Honors. I just wanted to briefly address whether it is the ex post facto or retroactivity analysis that applies here. Respondent is correct that no one was trying to convict or punish Mr. Carno using the penal law statute. It was nevertheless applied to him in this case because it made a collateral consequence of that statute apply to him.
There's no penal consequence, right? It's just a simple registration notice requirement, and I understand it's not that simple, but that's what we're talking about.
Correct, and that's why it's the retroactivity analysis and not the ex post facto analysis, because there is no punishment, because there is no conviction. So I would actually fully agree with that.
It sounds like what you're arguing is really, you're, as my colleague pointed out, is you're arguing ex post facto, but just dressing it in different clothes.
The ex post facto arguments around SORA have all been about whether SORA and SARA are so punitive as to nonetheless violate the ban on ex post facto laws. Here, this is conceitedly not within that realm. There are nonetheless other limits on whether a law can be applied retroactively. So while
What law is being applied here? Aren't we just applying the registration law as opposed to the penal law?
we're applying both here, Your Honor, and that's because there is no free.
How are we applying the penal law?
We're applying the penal law, Your Honor, because there's no freestanding obligation to register based on conduct. The SORA statute works by tying the SORA registration obligations to particular convictions under statutes. So because the SORA statute requires the identification of an offense that the registrant committed.
That's what SORA is all about.
Correct. Yes, Your Honor. So it's fitting two statutes together, and while SORA can be applied retroactively, that's only part of the equation here. The other part is that penal law, whether the penal law could be applied retroactively, and I would submit that it cannot, and ask you to vacate Mr. Carno's registration. Thank you.
Thank you. Clark v. New York City Transit Authority.
May it please the court, counsel, good afternoon. My name is Ira Slavitt, and I represent the appellant, Yvette Clark, in this appeal. In order to have obtained summary judgment as a defendant.
Did you watch the video?
I was just going to ask that.
Did you watch the video? Did you watch it?
I have watched it.
Okay. So have we all.
I understand.
So what's the issue?
The issue is twofold. First of all,
Okay.
you have a camera that's not the same angle as the bus driver. He's
I don't
right-
care what angle that camera is. The bus is traveling in the bus lane. The white truck is to the left of the bus. You see the white truck not even veer in, but just cut the bus off. It doesn't matter what angle you are looking at. You could be on Madison Avenue. It's the same. You see it. It's so clear. I don't understand your argument in terms of angles. What does an angle have to do with it?
Because it has to do with the visibility of the bus driver. He doesn't see this truck. You know, the negligence of the bus
The truck
driver
was
is
only
quite clear.
The period of time from when the truck turned in front of the bus until the truck hit the bus was under 2 seconds. Was 2 seconds. So how the bus driver didn't have time to react or to do anything.
Your Honor, I haven't seen a bright line rule in cases that says if there's not more than or there's not less than a certain number of seconds, that means no matter what
No, that's
else.
not the point. That's not what my colleague was stating. It's just that it was a split second. We're not saying that, it has to be 3 seconds, 2 seconds, 5 seconds, 10 seconds. It's a split second that truck just goes right into the bus.
Your Honor, it's not a split second. It's
2
few
seconds.
It's an issue for
It wasn't a
jury.
split, it was 2.
It's an issue. If the bus driver's accelerating. The defense is, and your argument is, you watch the video.
I don't have an argument. I'm not arguing. I'm just asking you questions based upon my observations of the video.
I understand. So your observation that the bus driver didn't have time, it's partly his own. A jury could find there's an issue of fact. It's partly his own making that he
Counsel,
didn't have
one
enough
of the-
time because he's not
Counsel.
watching. He could sound his
Counsel,
horn.
my colleague has a question.
Watching the video, I found it startling to see how the pedestrians on the sidewalk reacted at the point where the bus is cut off by the truck. Everybody jumped back in a startled way. It was, as my colleagues are saying to you, very much a split second from all appearances, and most likely a case where the emergency doctrine really and truly does apply. What do you do? What do you do when you have someone cut you off? The angle of the truck was astonishing.
If he's
And the bus was driving straight. The
Had a
bus-
clear lane. It was a clear lane in front of that bus.
the bus
Clear
driver is
lane.
paying attention. He sees the truck. If he honks the horn, nobody talked about that in the defendant's brief. If he honks the horn, the truck driver could go back to his left.
That just, the whole thing sounds speculative. If this happened, then the accident would have been avoided. All we know is a truck is accelerating into the bus lane, and immediately as the front of the truck is in there, there is an accident. Couple seconds, that's it. What is the bus driver to do? You say honk the horn, press on the brakes. Do you have an expert saying that that would have avoided the accident?
I don't have an expert, but
And how do we, I mean, again, we're dealing with the emergency doctrine, right? So how do we deal with that?
I didn't find any cases applying the emergency doctrine when the person claiming the emergency didn't see the situation at all before it happened. It's always a question of when was it reasonable for the driver to see the situation, and based on that point in time, did the driver react reasonably? I didn't see a case where the defendants, I didn't see anything, but now that I look at a video, turns out I didn't have enough time, which is the situation right here. You have an affidavit, you have a deposition testimony from a driver. It says, my foot's covering the brake, and the accident happened in the middle of the intersection. And then you have a video that shows in broad daylight, he's driving, the bus is accelerating. He can't have his foot covering the brake, the bus is
So let's talk
accelerating.
about accelerating. The maximum speed was 4 miles per hour.
Which, respectfully, Your Honor, gives the bus driver even more time.
And
That's another factor.
and the 4 miles was achieved just before impact.
He didn't apply the brakes until the impact. But that's the point, is the slow speed of the bus is another factor for a jury to consider, whether had the bus driver been paying attention and not been so flagrantly negligent and not seeing...
Flagrantly negligent, wow. You have time on rebuttal.
Good afternoon, Your Honors. Teresa Frame on behalf of New York City Transit Authority. Your questions demonstrate a thorough understanding of what's before the court. I won't belabor the points. I'll just point out that any speculation as to evasive action that the driver could have taken would not raise an issue of fact under these circumstances because...
Why is it speculation to say if the bus driver had seen, for example, the truck coming into the lane, he could have honked, he could have braked, and maybe avoided the accident?
Because there's no underlying evidence that the accident could have been avoided under those circumstances. So to say otherwise is sheer speculation.
Because the video shows what it shows, right? The video shows exactly what happened. And so to speculate that something else could have happened is directly contradicted by the video evidence, right? That's the problem here. If there's, maybe the argument is there's never a circumstance where you can find as a matter of law that the emergency doctrine applied, but if there was, this would be it, right?
Certainly, Your Honor, you're correct. If there are no further questions, I'll rest on my brief.
Thank you.
Thank you.
Yes.
I just would stress that I respect your opinion of what you perceive the video to show. I think there are issues for a jury to determine. There are other factors besides looking at that last split second before the impact occurred. Thank you very much.
Thank you both. Kim V. Francis.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff appellant. Before I start with the contract issue, which is, I'm sure, the issue that you want to discuss, I did want to discuss 5 separate claims that my adversary made, and my adversaries say support them, which I don't necessarily think does. Let me start with the most basic. The changeover from Elite Wall Street to Elite Daily. Now, I'm granted I'm a little older now. I do not understand the appeal of that original website. It makes no sense to me whatsoever.
Nor did I, but that's a whole nother issue.
Okay, I mean, I know I'm probably an alien, but...
I didn't get it. I didn't get it either, but, you know.
I'm sorry, I just had to get that one.
I don't think it was age, besides. I just think it was perspective, perhaps.
But the point...
I didn't get it.
But the point I wanted to make is that my client claims that that idea came from him, right? His argument was, look, I knew that the trafficking wasn't going to be what it should be, so I recommended the change. That would change, I believe, the disposition of the underlying motion, because that's not something that deals just with coding. Secondly, this poor worker.
That's not something that, repeat that?
That deals just with coding or with just a website. That's a fundamental
I see.
change in.
Isn't the issue here a question of actual apparent authority and what kind of authorities San Pedro had when he writes that email, putting aside the contract?
No problem. So Judge Singh, let me give you my hypothetical, because I love hypotheticals, as you know. Okay, I've got two partners. I've been with them for 40 years. I do nothing with respect to the business at all except write briefs, write appeals, do things like that. I decide I'm going to interview a employee, say a manager for my firm, right, an office manager. Without talking to my partners, even though I've never done it in 40 years, I sign a contract. And I say, you have a contract for a year with a year option.
Do what?
To work in the firm.
Well, that sounds to me not this hypothetical, because what you're discussing are matters which are within the ordinary course of a partnership's business, hiring, firing, attorneys, paralegals, secretaries, etc. That's not what we're talking about here.
San Pedro has an equity ownership interest in the new company. He's an equity partner.
So in other words, you're telling me that you can invite me to join your firm without consent of your partners?
If I deal with you, and I'm a partner in a law firm, and I say, I want Judge Singh to work for me.
As a partner, not as an employee, as a partner.
As a partner, well, I mean, I'm not sure there's a distinction with difference, but if I make that offer as a partner in the law firm, even if I never did it before, the risk of loss is on my partners because they're my partners. The risk of loss is not on the person on whom.
But doesn't that change by having me join your firm? Doesn't that change the nature of the partnership?
It does. And
how is that in the ordinary course of a partnership's business to be able to do that?
Because partners have the right to do things for that business. I think the way to look at this is through not the inherent unfairness.
Well, I hope your partners are listening to your argument.
They know I would never. They know I.
Because you have a new partner coming on board.
Judge Singh, take my word for it. They'd be happy to have anybody here as a partner, but that's neither here nor there. That's a risk of loss situation, and that risk of loss would have to have been borne here by the other partners because he is a partner. He's a 25% partner, and I mean, I've got 70 pages of emails, which you obviously don't want me to go over. They knew he was doing the work. They knew that he was there, right? And the argument that, well, we had no idea at all, and San Pedro saying, oh, I didn't even tell them, that's not even believable. This is summary judgment.
But your client even admitted that he really didn't know San Pedro's actual relationship, that he was a partner. He said he didn't know San Pedro was a partner.
He wouldn't. He wouldn't any more than in my hypothetical, Judge Weber, the person, the office manager with whom I was dealing would know that Brian Isaac just writes briefs and doesn't really get involved in office management. I think you have to look at that as a risk of loss scenario, because that's really what this is. And he's working, they're accepting.
No, but I mean, the case law does not support that. That really, the case law does not. In order for you to have a parent authority, there has to be, because clearly he didn't have authority. And so your only argument now is he had a parent authority. There has to be a significant factual basis to find that he had a parent authority. Your client said, I didn't even know who he was. So that automatically disavows any apparent authority.
Scarpula, I don't think that's exactly accurate. I don't
I could disagree with that, but tell me what facts you think show apparent authority.
Well, he's asking him to work in a website.
Okay, but they're friends from college,
No,
right?
100%. But he's also friends with one of the other principals from
Okay.
college, okay? There are, 80 pages of emails going back and forth.
Between just the two of them?
Not only. No, if you look in the February emails when they were asking for a meeting, okay, and that's well after, I'm sorry, Judge Weber, can I just?
Yes, please.
That's well after, that time period was over. They're asking for a meeting with him. He has nothing to let him believe in this situation.
They're asking for a meeting. They're not saying, hey, partner, come on down, right?
Of course
So
not.
exactly, all the evidence shows that there was no apparent authority.
Well,
if they thought he was a partner, why wouldn't they be saying in those emails, come on in, partner, let's have a discussion?
Well, it's not there. If it was there, we obviously wouldn't be here, right? Because that would end the situation. But I think you're dealing still with a summary judgment motion with someone who's an actual partner in the enterprise with, months and months of emails dealing with his work. So even if you look at it from an apparent authority situation, this isn't a situation where he has no reasonable belief that the person with whom he's dealing is a principal authorized to have him do that work. Thanks.
Thank you.
May it please the court, my name is Alan Heller, and I am just for respondent Arabab, and I'm going to argue for all three, but Mr. Teresiano has 1 minute to argue for.
So, counsel, I'm going to begin with a question. Let's assume for the sake of argument that we buy the defense that there is no authority, there was no authority, and there was no apparent authority for San Pedro, also known as Francis, Mr. Francis's real name, to bind the partnership. How does that impact the claim that the defendants were unjustly enriched by the creation of the website by the plaintiff?
If they were unjustly enriched, Your Honor, then Mr.
Well, $50 million sounds like a lot of money to
It's a lot of money, but he was a coder. This
sorry,
wasn't
he was
his.
a what?
This wasn't
A
his
coder?
pet project. He was a coder. He created a web. He created, based on his template, he created a website, Your Honor, and he could ask for the world. 3 years later, this project was sold after he disappeared for 3 years. A lot happens in 3 years to build up a website. It just doesn't happen like magic.
But those sound like factual issues to be determined at a trial as to what he did, what the value of what the value of the benefit he conferred upon you, because this is unjust enrichment and not quantum merit, correct?
But the unjust enrichment, its value of services provided, his understanding.
It sounds
they
like,
can't be.
looking from your brief, it sounds like you conflate unjust enrichment with quantum merit. Because unjust enrichment, we're looking to see what are the benefits that this alleged coder provided to you that you resulted in a sale of $50 million.
But the benefits that he provided, he claims he wasn't paid to do the work. First of all, he was paid. And there is evidence that's undisputed that he was paid $250 a week to work on this project.
But counsel, this is different from saying, you have my jacket and you've been unjustly enriched because now you're wearing it all over the place and you look good. It's not quite the same thing when you build a website that's the primary vehicle by which the defendants realized revenue, grew a business, and so on and so forth. I mean, you're minimizing what the creation, what the building of a website means in this day and age, aren't you?
No, I'm not. You know, my adversary likes hypotheticals, okay? So let's go to a hypothetical. I'm a lawyer. I create...
That's not a hypothetical?
Okay, that's not a hypothetical.
Oh, because I was going to say, Dan, you shouldn't be here arguing, but okay.
Okay? Sorry, I'm not a lawyer. I now am a lawyer.
You play one on television.
I play
Okay,
one
go
on
ahead.
television. So I want to be a lawyer, and I create a document that starts a whole entity that becomes a multi-million-dollar entity that puts all these groupings together. I create all the licenses and everything, and I'm the one that created it, okay? But I'm hired to be a lawyer. He was hired to be a coder. And the Leahy case, the reason why they allowed on a motion to dismiss that unjust enrichment claim for equity as well to go forward is because there was a promise of equity that was alleged. Here, the only promise that's in a document is a promise of revenue, or at least an alleged offer of revenue. There was no promise of equity. There never was, and forget about the authority. Even the very document they relied upon, this July 7th email, talks of 15% of revenue. It doesn't talk about equity. So the only basis he would have under the Leahy case would have been if he had a promise of equity, not a promise of revenue. So yes, if he wants to argue that he's entitled to 15% of revenue, that's a separate issue. But he never makes that argument because he doesn't want it. There were no revenues. And that's the point. Yeah, as Your Honor's left, there wasn't going to be any revenue from a stock tip site by the women who were going to give the stock tips. It was a bunch of college kids who thought about it. Then the whole concept changed. He disappears. My clients go up and sell it for $50 million 3 years later. Then he disappears for another 3 years. He never showed up until 6 years later. If I'm a partner and I think I have equity in a project and I know it's been sold for $50 million, don't you think when it's sold 3 years, and he admits he knew about it.
You know, your argument sounds like to me that I'm the trial judge hearing the evidence, making a determination, because you're asking us to essentially weigh evidentiary facts, which I don't think would be appropriate on this kind of motion.
But first you have to get there, and you don't get there under Leahy because there was never a promise to give equity. And that's why Leahy went forward. This court allowed Leahy to go forward because there was a promise. Here there was no promise.
Thank you.
Good afternoon, Your Honors. May it please the court, I am Peter Teresiano for the respondent San Pedro. I'd like to just comment briefly on appellant's argument, which I think, if I heard it correctly and you responded to him correctly, would turn the whole business law on its side, saying that partners could give away equity of their other partners without their consent. So to take that into perspective here is a leap of faith and a stretch of the law, which I don't think any of us can hold any credence to. To support Mr. Heller's arguments and to address Judge Singh's point, there was never a meeting of the minds. There was never a definitive offer. So there was never a contract ever formed in this sense. My client sent the appellant an email in the middle of the evening. There were a bunch of college kids. They were excited about this idea, and it was a bunch of banter. These guys, in their deposition transcripts, said they enjoyed their own little libations. God only knows what they were enjoying at or before the time of this email. And then to get to the point of the unjust enrichment claim, he was paid for the services he rendered. He never once, in the 3 years after the last email, spoke to these guys again, sought a K-1, sought any kind of paycheck, any compensation whatsoever. The company is sold twice. He admits that he knew of them, those sales. He admits he spoke to attorneys about it. If he had any belief that he was entitled to either revenue or equity, something would have happened. And as I have said to the lower court on this point, I think the appellant might have been speaking to counsel at a meeting, a party or something, and said, hey, maybe we have something here. And that's how we've gotten here today. They've tried to throw enough stuff against the wall hoping something sticks when there isn't anything here other than an email between a bunch of college kids.
Thank you.
That sounds to me like it's speculative itself.
Well, it is, but is it relevant at all in terms of the delay in attempting? I mean, the company is sold twice. There is a significant delay in terms of...
There is. And I would make the argument that it shows that he's probably more clueless than he ought to be. If he was really looking to be greedy, well, the first thing he would have done was he would have sued. He wouldn't have waited 3 years and then waited another 3 years. Can I just point something out? They keep talking about the 7-7 email, and they're just not reading it the right way, okay? I'm going to read it to you so that there's no debate. It's on 1283 of the record. All right, I'm going to leave out the stuff that's unimportant. They talk about, originally, you want a stake in the company, and now I'm reading. This is he talking about Arabov, was like, you are crazy, of course. He has to be in on this with us for the whole thing. With that in mind, he, talking about Arabov, initially offered 15% of overall revenue to DOTS. We toyed with the thought of breaking it down, BTW, I think that means by the way, stock marketing income and ad revenue membership, and that gets too confusing, and I don't want you getting stuck on the short end of the stick. So we're, not him, we're going to do an all-in on this blank, I won't use the word. Let me know if you're cool with that piece of the pie, or if you want to counter.
So taking that statement, piece of the pie, and applying it to unjust enrichment, how does that work?
So assume you hate my argument on
We don't hate here.
I'm assuming. Assume you don't like my argument on agency. It's irrelevant. The cases clearly say, as you know from reading our brief, page 48, you can have a breach of contract claim with an unjust enrichment claim. If you find there are questions of fact as to whether he's entitled to an equity interest, he can get it on the breach of contract, or he can get it on the unjust enrichment, and these fine gentlemen have a right to try that case at trial.
Is it your position that the promise is based on the latter statement that you just read?
Yes, 100%.
Thank you.
Thank you.
Thank you all. Rocklet Triumph versus Concept Salon. Yes, you may proceed.
Good afternoon, if it please the court. Paul Gruber, Borgold, Sinol, Schuler, Naines, and Goydell for the appellant. The relief of the appellant is seeking today is simply reinstatement of its complaint against the guarantor for the treatment that this court afforded similar claims in the Conti and George Billis matter. Unless there are questions on that point, I don't plan to belabor it. The elephant in the room on this case really is whether it is the argument with respect to the fact that this is an appeal from a judgment as opposed to the
Could you address that,
order.
please?
What?
Could you address that?
Absolutely. The order in this case from Judge Getz clearly indicated that it was non-final. There's a little box on the bottom that's checked off. I imagine
What
that.
remained at that point to be decided?
What?
What remained at that point to be decided?
There's certainly the case with respect to the tenant, but Judge
No, but as to
Getz's
this-
order.
As to this party, what remained?
Well, Judge Getz's order is a little awkward. I don't know. There's a bit of a drafting inconsistency there. He first denies summary judgment to plaintiff against the guarantor based on the fact that there are issues with respect to how much is owed. And then in the very next sentence, he goes and dismisses based upon the guarantor law alone only. And those are inconsistent, frankly. I don't know how you reconcile them. It certainly doesn't go.
Why didn't you appeal the order?
I don't have an answer for you because I don't know. I don't know. The court, the 5501, which deals with reviewability as opposed to /jurisdiction of the court, and certainly the court has a jurisdiction from an appeal from the judgment, talks to whether or not the order necessarily affects. It certainly does. This was a judgment that was directed by the court. It wasn't directed by, this isn't one of the situations which Geronimo and Guzman and the Pollock versus Moore cases, from which I read, suggests that the plaintiff, realizing it had a problem in those cases, went and settled the judgment. Here, the judgment was settled by the defendant. If the defendant thought that the order alone stood, then what was the need for the judgment? What was the need for?
That doesn't follow. The fact that there's an order that's final doesn't mean that he has no need for a judgment. There are reasons you might still want a judgment to show to determine the finality.
Well, there'd be an order there
The fact
too.
that he got a judgment doesn't have an effect on whether or not the underlying order was final and conclusive.
So, and counsel, I'm looking at the dates. So the order is signed in August 23rd of 22. The judgment comes in less than a month later on September 13th, 2022.
Yes.
But the appeal comes in June of 2023. Now, Melendez is decided by the Southern District in 2023. And there it says that the guarantee law violated the contract clause because that it barred the landlord forever from recovering rent to which they would be entitled from a guarantor during the pandemic period, right? Is there a relationship, that you articulate a relationship between the timing of the appeal and the decision in Melendez by the Southern District?
I'd only be speculating.
I beg your pardon?
I'd be speculating as to why at that particular moment the client made a decision.
That was not provided as an excuse for the delay, am I right?
Well, can I continue?
Please.
Thank you. The judgment in this case, and the judgment, I mean the September document, was never served with notice of entry, so the appeal from that would have been timely.
So the answer is no. Thank you.
Good afternoon, Your Honors. Bruce Handler for the respondents, and specifically the personal guarantors, Helio D'Souza and Andre Piccolo. To the point you raised about the finality of the order, I don't think there's any question that the order was final. What it did was dismiss completely the complaint as against the two personal guarantors, and it left the action pending as to the commercial tenant. and that action is still going on in the trial court below. In fact, the order couldn't be clearer what Judge Getz did, because he...
Well, it could be a little clearer.
A little clearer, but
little.
it's pretty clear, I think.
But, I mean, we understand.
Because he severed the case, in fact.
Yes.
And in fact, he ordered the guarantor's lawyers to serve a notice of entry. So it wasn't happenstance that a notice of entry was being served. It was specifically being served. And I would suggest that the plaintiffs, the appellants, were on notice that there was a final order dismissing these parties for good, and they had the burden to timely appeal, and they did not. And as we cited in our brief, there is a notion of party finality, a doctrine of party finality, which this court recognized in, I believe, the Shaw case, which says that when you've dismissed a case by order as to specific parties, that is a final order as to those parties.
So is there any reason we shouldn't just dismiss the appeal?
No, I think you should.
Thank you.
Okay? Thank you. I will sit down.
Unless the court has any questions or wants to hear on any other issue, we'll rest on our brief.
Thank you very much. Thank you both. Kayla versus PS&G, Long Island. Please.
May it please the court, Daniel Kotler from Lester Schwab, Katz and Dwyer, on behalf of defendants, appellants, PS&G, Long Island, and Wilson Construction. We have a situation where we ask the court to essentially choose its reason for dismissing the labor law claim. We don't have a covered activity because the action of filling in just blowing the bark into filling these holes was essentially landscaping. But more importantly...
Counsel, did you
Go ahead.
Did you see the depth of the hole? I mean, I don't know what kind of landscaping you're familiar with, but that was a trench. That was deep. That was deep, and that was not the equivalent of, to quote the brief, of blowing material into a flower bed. It was a 12 foot by 15 foot hole that was up to 3 feet in diameter. I don't get it.
Well, I would argue, we do argue that filling in that material is not a covered activity, but if we step back, we have the larger issue that plaintiff and his company weren't engaged in that work of infilling, of actually blowing that bark in.
But that was necessary in order to replace the 200 wooden utility poles, right? With steel poles.
They had last worked several weeks ago, and
that was because of the snow and the storm or whatever, the cold, and the holidays, right?
Correct. They had performed work in December. They had left this anticipating a return after the new year, and that hadn't happened because of the weather.
Right.
And then there's this.
It did eventually happen. That's
they were anticipating. Sorry.
That's when the accident occurred. It did eventually happen that they came back.
They anticipated eventually returning, but if you look at the text messages between plaintiff and his employer, they were essentially getting antsy and saying, our equipment is sitting there while PS&G and Wilson this project isn't moving forward. We need to retrieve it so we can do other work.
But didn't the supervisor from Wilson suggest that there was going to be additional work, but just not on the day of the accident? They didn't expect them to be there. Doesn't that suggest that they're there to do work?
There was an anticipation that they would eventually do other work, but they weren't doing it on that day, and this work was not, this isn't the equivalent of adjusting a crane so that we can do work over here. This isn't the equivalent of a cement truck that we're cleaning out as part of the daily work.
Why not? The auger is jammed with ice. In order to put the wood chips in this large hole, as my colleague eloquently stated, isn't that similar to all the other sort of construction work going on there in terms of preparing a site, preparing a place for work?
It's not equivalent to it because wasn't in the process of doing it. It was a result of having been left unattended for other work, and it was the employer maintaining the employer's own equipment separate from the project. This wasn't the routine work. If the court would allow me, I'd like to, since we do have some other arguments, I'd like to touch on those. We also have the argument that plaintiff admitted this is his own foolishness in reaching in rather than turning it
So
off.
wasn't there an explanation provided by the plaintiff to the extent that this person was he medicated at the point where, or injured at the point where he's giving these statements, and he was saying basically, oh gee, I was stupid, that kind of thing?
Plaintiff's appellate papers make that. That argument wasn't below.
You're taking the statements about being dumb and saying, I'm sorry that this happened as being admissions against interest?
He's talking about, I did this, I reached in. That's very different from, oh, I slipped, I fell in. And that brings us to...
Well, he says what he did could be considered dumb by allowing the pressures of a job to determine whether or not I did anything more, right?
But that pressure was to have it worked on before the mechanic showed up. That wasn't related to any urgency for Wilson or PS&G. Because his urgency was simply for them to have their mechanic to work on it.
Yes.
Yeah. And it also goes into, in terms of those admissions, we have this this fundamental question, which also reaches into the question of indemnity, of was this something that came out of his employer's work that they maintained, or was this slipping on ice? And this clearly was an issue of the way he performed his work. And those admissions also very clearly go into that issue. That this wasn't a question of, oh, it was a poorly maintained parking lot or something. It was an unpaved dirt field. That's where they left their equipment. And the employer determined how that work was performed.
But these are all issues of fact that will go before a jury, right? Because it's your motion for summary judgment that was denied.
It is our motion for summary judgment. In terms of whether there's a question of fact, especially in terms of the slipping versus a reaching in issue and the mechanics of the auger and way the work was performed issue, we have plaintiff's admission that it happened because he was dumb, and we also have his admission that to the extent there was ice...
He was dumb. I mean, there's no question about it. He shouldn't have been sticking his hand in there. But that doesn't mean that he didn't slip on ice and that's how the accident occurred. That seems to me to be an issue for the fact finder and not for this court.
I would argue that there's a very different issue of I slipped and fell into something versus I reached into it. And we also have plaintiffs...
You can't be dumb and slip at the same time, right? Yeah, you have time, rebuttal.
Okay. Thank you, Your Honor.
Good afternoon again, Your Honors. Brian Isaac. I represent the plaintiff respondent this time.
So now you have another dumb, you have another dumb plaintiff. You had a dumb one on the contract case, and here's another one.
Yeah, I don't...
I'm telling you.
He does everything.
That's my luck, right? I can't catch it. Can I bring to your attention a case that came down today that deals with this issue?
Did you provide us with that?
Yes, Rodriguez.
Yes, thank you. Appreciate it.
Rodriguez against Riverside Center. I gave it to Mr. Kotler before he was here. Your case number is 2023-03425. It deals with the question of work, what kind of work do you have to do. Look, there's no question that there are questions. In fact, I'm not moving for summary judgment here, right? And the plaintiff says that they were getting the machine ready. His coworker Blair says they were getting the machine ready. Martis, who's the Wilson worker, says they were getting the machine ready. So
your friend argues that we don't know exactly when the work was going to be done. It's anticipated, but it wasn't necessarily anticipated that it was going to be done that day or even the day after.
So my answer to that is very simple. It's your case in Campisi and Pratt's. Pratt says we don't isolate the moment of injury. We look at the overall context of the work. As Your Honor said, this is a removal of gigantic poles. Poles are structures under the label of themselves, and the job couldn't have been completed unless they were filled in. There was an environmental concern.
No, but counsel, how do you, may I interrupt you, how do you deal with the defendant's argument that this wasn't this was the company bringing back its equipment, having nothing to do with working. There was no doubt that they weren't working that day, and there's no evidence that they were going to work anytime soon. The evidence were they wanted their equipment back.
Well,
Is that,
yeah, so I would tell you to look at, don't even look at my testimony, look at the testimony of Jonathan Martis, who said that he had been informed that, who contradicted Wilson's testimony on 829 of the record. The plaintiff actually said in his testimony at 244 of the record that a Wilson employee asked him when they were going to get ready because they were behind the job. And as you also know, this job was extended to the 31st. So the fact that he might not have been performing work there because they couldn't get the auger working doesn't mean that it doesn't fall within the label, especially given your decision in Karwoski and the Court of Appeals affirmance of your decision in Garish, which says that staging work that has to go into the ultimate work that's being done on the site falls within the ambit of the label.
I have a question about the, how do you call it, PSEGLI? Are all of those letters really pronounced of the report, which said that the plaintiff grabbed the ice quickly while the auger was moving? Was that statement attributed to anybody at any point in time?
Well, from the PSEG report, it wasn't. As you pointed out in your questioning, Blair said that he never spoke to Wilson about, to the police officer about anything. The police officer was, police officer Huey, I believe is his name, said he didn't get into how the accident happened with respect to the plaintiff. And the plaintiff did test it. Well, I mean, you saw his hand. He was gross. He lost all his fingers. He was heavily medicated, and he wasn't really there. So that is just a statement that's made without any factual content. And I think what he was saying with respect, if I can, just with the emails, I think he was saying he did a stupid thing because he got his hand in there. I don't think that's sole proximate cause, because the industrial code 23-9.2A and 23-111 says you're not supposed to have this type of machine there. It's supposed to either be guarded, or if it's not working, if the interlocks aren't working, it has to be removed. The testimony was undisputed that all three of the machines didn't have the interlock on them. So look, I'm not moving for summary judgment, but there's no way that I lose summary judgment on this record because there were multiple contested issues of fact that can't be resolved summarily.
So can we go back to the staging 1 second? You refer to it as staging, but your friend says that the equipment was being cleaned to be used for another job. So staging means that it's going to be used for that particular job.
The evidence doesn't say, that's his interpretation of the evidence. It's certainly not what Blair said. It's certainly not what the plaintiff said. And it's certainly not what Martis said. You don't even have to look at the plaintiff. Martis specifically said that there was a problem because they were suspending the work because the blower machine wasn't available that day.
Would not be able to work because the blower was broke.
Correct, that day. And even if it was the next day, I don't think it would matter. I mean, you read both of the affidavits, obviously. They were talking about feeling pressure, but the pressure was to get the job done. It wasn't to bring the machine somewhere else. So I think it's all part and parcel. And again, when you have different ideations of what statements mean, you just don't get summary judgment. It's a drastic remedy. If you don't have anything else, I'll sit down and let my adversary talk to you. Thanks for listening to me.
Good afternoon, Your Honors. May it please the Court, Otto Chang for the third-party defendant respondent, J&R. Your Honors, I have the risk transfer piece of the case. The third-party claim that is on appeal, that is at issue here, is the claim for common law indemnity against J&R. On the one hand, of course, while I join in the arguments made by my colleague for PS&G on Long Island, and that, of course, if the complaint is dismissed on appeal, then obviously the third-party complaint is rendered moot by operation of law. That being said, however, Your Honor, on the other hand, if this honorable panel agrees that there are questions of fact, and if the plaintiff's version of the events that he allegedly slipped on some ice is to be given any sort of credibility, then in that case, the lower court correctly denied summary judgment on the common law indemnity claim against J&R. Notwithstanding the loss of multiple fingers, if there is a question of fact as to whether the plaintiff did slip on a icy condition, if that is to be given credibility, then that's obviously a question of fact as to whether that is a site condition for which the owner is responsible and which precludes a ruling of common law indemnity. That being said, however, Your Honor, I know I'm speaking a little bit out of both sides of my mouth. I do agree with PS&G's arguments on the one hand, but on the other hand, if there are those questions of fact, then common law indemnity was properly denied to PS&G on Long Island. If there are no further questions, I will simply rely on my briefs. Thank you for the time, Your Honors.
Thank you.
Your Honors, on the Rodriguez case, I mentioned in my initial statement, in my initial argument, the case of a cement, and I think that's the case I was referring to, and the distinction is, excuse me, the distinction that I mentioned is exactly how I would distinguish that case. That case involves every time you use the machine as part of the work, you have to wash it out. So it's
So the machine here is not part of the work? The machine is to shred wood chips so they can fill the trenches or the holes?
No, the machine, the work here that was done, the dirt.
Are they manually making wood chips to put in the hole?
No, that's not the work that he was injured doing. He was injured cleaning it out of ice as a result of it having been left out exposed to the elements.
In order to prepare the machine for, according to the plaintiff's version, to prepare so that the work could be performed.
So that the machine would be I would argue that it's so that the machine would be functional for any use. It's more akin to.
Well, fair enough. It's your motion for summary judgment. Why isn't plaintiff entitled to all those favorable inferences at this stage?
Well, plaintiff certainly is entitled to the favorable instance. That's the summary judgment
Isn't
standard.
that an issue of fact then at this point?
I don't think it is an issue of fact, because if you look at the text message exchange, you see, and also at the nature of the work being done, this isn't work, this is more akin to a truck. If a truck breaks down and you have to repair it at your warehouse, if Amazon has a truck, they need to fix that truck to eventually make deliveries.
They must fix the truck. Amazon,
Yeah.
I need my delivery. But I'm not really understanding, in all seriousness, the difference. I think I sat on Rodriguez or something similar to that with the cement and clearing the cement from the truck. It's the same issue, because in order for this equipment to be used, you have to clear it of the ice.
The difference is it an ordinary part of doing the work every day? I do the work, I take my tools, I put them away, then so that they're organized. I wash my brushes if I'm a painter,
Well,
as opposed to.
Yeah, ordinary given weather conditions. If there's ice buildup, then it would be ordinary to remove that ice.
But
it's ordinary in the winter for planes to de-ice, because in the winter there's going to be ice. So ordinary, you have to take ordinary in terms of the situation.
I understand that argument, Your Honor, but I would differentiate, because this wasn't, there was ice on the day of work. This was an issue because it had been left exposed to the elements for several weeks or approximately a month, and I think that differs it. And I would also focus and emphasize, because obviously we do want indemnity, on the common law negligence issue, that plaintiff admits any argument that he slipped because of a general icy condition is speculative. He can't say that, to the extent there was ice on the ground, it wasn't simply ice that he pulled out of the machine. And we get to, this accident was because of the way his work was done and the equipment his employer provided. And so we should, at the very least, have summary judgment dismissing the common law negligence and therefore giving us indemnity.
Thank you.
Thank you, Your Honors.
Martinez v. Partnership 92.
May it please the court, Leonard Porcelli on behalf of the Appellant 92 Partnership. Your Honors, the lower court erred in denying summary judgment to this out-of-possession landowner. What is important here is that there is nothing in the record showing that a safety bar was an inadequate protection. And, but for the failure of the tenant to deploy that safety bar, this accident could not have happened.
Yeah, you can go.
Can there be more than one proximate cause of an accident?
Everything,
Yes or no?
yes.
Okay.
Yes.
So in this instance, the plaintiff claims that there was a bump out of the facade, i.e. a structural issue. Could that be considered by a jury, including the argument that you make that it was a failure to attach the safety bar? Isn't that an issue of fact for the jury?
Well, the argument there is that there's a slight change in the angle, but
Right,
there's
which-
still
which-
all speculation.
Which limited the ability to lock it in place, right?
No, it absolutely could have been locked in place with the safety bar. They just did not use it.
Because of the bump out. Apparently, the expert testified that it's supposed to be a 90-degree clearance, and there was only an 88-degree.
But the safety bar would absolutely resolve that issue in its entirety. It would be a non-issue.
Do you have expert evidence that establishes that, that's not contradicted by any other evidence?
There's decades of use of the safety
No,
bar.
that's not what I'm asking you. Is there any expert evidence that supports your contention that has no contrary evidence in the record?
There's nothing in the, no, there's no expert testimony, but there's no.
No expert testimony by you. There's expert testimony by the plaintiff.
Yes, there is expert testimony. I did not provide expert testimony. However, there is nothing stated in the respondent's expert testimony that safety bar would not have prevented the accident in its entirety.
Two different questions. One, isn't there testimony on behalf of the plaintiff to the effect that there was no safety bar available on the day of the accident and there was no sign as depicted in the photographs that are attached to the record? That's one. The other is there any testimony that the safety bar, if in fact it had been provided, which is a question here, would have secured the doors at 88 degrees, at an 88-degree angle?
If the safety bar was deployed, it would not be possible for those steel doors to collapse upon
I'm
someone
not
going
asking
down
that
the steps.
question. I'm saying the safety bar would have a defined length. And do we have testimony that the safety bar fit in the little holes at an 88-degree angle as opposed to a 90-degree angle?
Well,
Could it have been too small, for example?
Well, we have testimony of over 10 years of use of the safety
So your
bar.
answer is no, there's nothing specific that says that it would.
Just the custom and practice and the prior use, and without any incident, no prior
Is that
incidents.
sufficient, in your view, to give you summary judgment at this stage?
Yes, Your Honor, I do believe that that's appropriate because there is nothing to contradict that. If you accept that as a fact,
But there's an expert affidavit saying that there is a structural defect because the gate doesn't open fully as it should.
it could open further, yes. But again, that's moot if you have a safety bar and a procedure in place that has no prior incidents whatsoever, and it's a foolproof procedure.
Except that the plaintiff denies that the bar was there or the sign was there on the day of the accident.
But then we're talking.
Straight up says it.
Yeah, we're talking about the liability of the tenant then for not having that there.
Well, so no, because if the accident was caused by the bump out, which the plaintiff's expert attested to, or opined rather to, as opposed to not having the bar, then it's the owner, right?
But that would be, everything about the bump out is predicated upon speculation. Force
Well,
that's
I mean,
applied.
if you don't like the expert's testimony, which, okay, but then you have to raise it by putting in some expert testimony, not by seriously only by the fact that the accident hasn't occurred in the past, right?
Well,
there are plenty of
there's no notice.
plenty of bumps in the street that don't cause people to fall until somebody falls, right?
Again, there would be no notice with respect to the owner of any prior incidents.
But I don't think you argued that.
Yeah, notice was not, I didn't see that as an argument. But you have time on rebuttal.
Yes, well, okay.
You have time on rebuttal.
Okay, thank you.
Fisher? You only have 5 minutes.
Good afternoon. May it please the court, Tim Shapiro from the law firm of Strakowski, Drachman, and Shapiro on behalf of third-party defendant Fisher Foods. The issue for my client's appeal is with regard to the grave injury. And the specific injury that's been alleged is a brain injury, which, as we know under Rubius from the Court of Appeals, has to be an injury severe enough to render a plaintiff non-employable in any capacity. We have a plaintiff here who says,
Well, he said he took
I worked.
the exam. He took the exam to be a bus driver or something like that.
Well, beyond that, Your Honor, he actually worked from approximately 1 month after the accident, which was July 2016, until after his neck surgery, which was October 2017.
But if you look at the injuries, I mean, they are substantial in terms of the staples to the top of his head.
I'm not here to argue that they're not substantial, and I mean no disrespect to the plaintiff. And I point out, by the way, that on this case, as with all grave injury cases, the issue for my client does not impact the plaintiff's claim whatsoever. It's only on the third-party action for common law indemnity against my client, Fisher Foods. It does not impair the plaintiff in any way or what he can collect on a judgment.
Is there an issue of fact with respect to grave injury?
There is not. And the reason I say that is,
notwithstanding the 5 surgical procedures, including 2 C-spine operations, 1 L-spine operation, 2 operations to implant a neurostimulator, and what else? He had a TBI.
Every injury that Your Honor mentioned do not relate to the grave injury.
Well,
and
TBI, let's
the
focus
TBI
on
is the one
the
issue.
TBI.
Yes, correct. And on that issue, the plaintiff has said he was working, could work, intends to work. The reason he stopped working, and he was very clear about it, in his testimony, this is from the plaintiff himself, he stopped working because of lifting and carrying, and that was the only reason. It says it there on page 360 of the record. The only reason he was not able to continue working, and this court has said, in Anton in 2012, it has to be the brain injury that renders him unemployable in any capacity. That's what the Court of Appeals has said.
Sorry, counsel, there's no expert testimony here that the alleged TBI made the plaintiff unemployable on a permanent basis?
The issue here is not an expert issue. It is a factual issue from the plaintiff himself saying, I worked.
So in other words,
I worked for a year and a half. I had 2 jobs.
So you want us to make a factual decision here. Would that be appropriate, or is that better left for the trial court?
I think it is absolutely appropriate, Your Honor, because
For whom?
we have a factual issue.
No. For whom? The question was for whom? Trial court or the appellate court?
It is for this court to decide on the facts, on the evidence, when a plaintiff, as a reminder.
But counsel, I'll remind you that the plaintiff's experts, who included a neurologist, a doctor, and 3 doctors in all, PhD, they said that the plaintiff was permanently unemployable. Is that an issue of fact?
It is not when the plaintiff says, I was employable, I did work.
So that's credibility, correct? That's credibility.
That's not credibility.
You're asking us to say, essentially, that he's not credible anymore with respect to the claims of unemployability.
It would be an issue of credibility if somebody came and said, I was there, this plaintiff didn't work. He's not telling the truth.
Why would it
Never
not
worked.
also be an issue of credibility? He said he worked in that he was employed. We don't know how well he did in terms of that employment. He says he took he passed the city bus driver's test, which is questionable in my mind. But also, he said he was opening a real estate business. He did other deliveries for GC Food and worked as a meter reader for a construction company. The credibility issue, I would think, is how well he performed these duties. And we have the expert, the neurologist, and the 3 doctors who are testing, who attested the fact as his permanent injury. So wouldn't that not be credibility in terms of whether he did in fact perform these duties to the extent that they should have been performed, and he was in fact employable?
It would not be, because no one has said, I was there and he didn't do his job very well. He got fired
because we're not at trial. We're just at the motion for summary judgment.
That's correct, because it is undisputed that this plaintiff worked there and only stopped working because of his neck injury. There's no one who says, no, he stopped working because of his brain injury. No, there's no claim on that. There's no contradictory evidence. An expert's opinion does not extend that far. And what I was bringing up before was the premise of grave injury is it's supposed to be very narrowly applied. What we have here is my respected colleagues are essentially seeking to extend that to say, if someone comes and says, hey, look, let's say it was a total loss of use, and I'm moving my arm, to have it be sufficient for an expert to say, no, he can't, even though he says he can and he is, then we disagree with that. An expert's opinion can only go so far, and it would essentially effectively be extending the reach of grave injury. And when the legislature passed this statute, it was supposed to be applied very narrowly. It's supposed to only these injuries listed in the statute. So to have that extended to say, look, we have a plaintiff who says, I worked, and nobody's disputing that. I worked for a year and a half. To have somebody come and say, no, we don't think you can. That's not sufficient, because that's not an issue of credibility, because that's not somebody saying, no, he didn't work. I just don't think he should have. And to answer the question, there's no evidence whatsoever in the record, no contradictory evidence saying he didn't do it very well, he wasn't good at it. He actually said he held down 2 jobs. So I do agree, in the future, yes, he took and in fact passed that bus driver's license test. And by the way, again, no dispute on that. Nobody's saying, no, he didn't. And by the way, that's a test he has to take intellectually. That's the future, but he's already worked for well over a year. And that's just a matter of fact. I do appreciate my time is up, so I'll reserve for rebuttal.
Plaintiff.
Please, the court, Henry Davley for the plaintiff appellant. If I can, I'll take the second part of this, since there's 2 appeals here. Just to clarify, there does not seem to be a dispute that my client has a traumatic brain injury. There's objective evidence.
Your client appears to dispute it.
No one appears to dispute it.
Your client appears to dispute it.
My client, to his credit, tried to go back to work. He went back to work with accommodations. He went back to work with a very receptive employer who was able to give him accommodations. When and as it developed with his injuries and it was more known, he wasn't able to continue with his job.
But as your friend stated, there's nothing in the record that states that. There's no affidavits or anything that said that he was not able to perform his duties as expected.
We have a statute that we have to follow literally that says, is there a traumatic brain injury and did it result in a total disability? We're looking at a period of only 1 year after the accident where my client, to his credit, tries to go back to work. We have 7 years now from 2007 to 2024 that he's totally disabled because of this traumatic brain injury, as well as the cervical injury, as well as the lumbar injury.
Is there any documentation to the effect that the brain injury, what is it called? The collateral TBI injuries persisted throughout the course of his employment and after?
The nature of a traumatic brain injury, he had intracranial pressure. That pressure causes something known as ischemia, which eventually ends up in necrosis. So it's an evolving process. Your brain just does not die immediately.
Is it documented?
Yes.
In the record?
It's in Dr. Bhatia's records. It's in Dr. Krishna's record.
The vocational, who's the vocational? Yeah,
Dr. Krishna is Westchester Medical Center.
somebody was a vocational expert.
We have, yes, Mr. Pravda, he makes the same
yes.
findings as well. Unfortunately, or fortunately for my client, or not fortunately, he has 3 different sets of injuries that would put him out of work. The determination of which injury caused him to be out of work, for me, doesn't really matter for trial. For purposes of the traumatic brain injury and workers' comp and the section of the law that we're applying, of course it does. So your court does not have the luxury of saying, well, we have more than ample amounts of disability from the cervical to the lumbar to the traumatic brain injury. But the traumatic brain injury is well documented clinically and objectively. So it exists. It qualifies under the statute. The fact that my client went to try to work for a year should be held against him.
But the fact that workers' comp determined that it was a grave, that he was, because he had a traumatic brain injury, thus rendering him unemployable, does not mean that we have to find that it was a grave injury.
No, you can do whatever you want, but if you look at the statute, objectively as a traumatic brain injury, and number 2, he's been out of work now, totally disabled for 7 years.
Can you quickly address, you only have 2 minutes left, can you address?
As the court noted, there are multiple different problems with this property. He is not an out-of-possession landlord. It's a very large building. The landlord is there with 2 different property managers. There's the right.
The argument is that that there has never been this kind of accident before, and so of course there was a safety bar there, et cetera, et cetera. The partnership has no culpability here at all.
The landlord under New York City Administrative Code 28-301.1 has the duty to maintain a safe building. He just can't close his eyes to what the tenant is doing. What the tenant did was to take a bump out, made it very fancy, but what the bump out does is it causes the door to stand up at 90 degrees. What you need for this 40-pound door is for it to go beyond the 90 degrees. Once it gets to beyond the 90 degrees, the weight of the door itself holds it open. What they did is they put the door to a vertical position where the trip pressure required to close was only 1 pound, according to our expert, Mr. Marletta. That's ridiculously dangerous. There's also
Was the bump out in place when the gourmet food place rented the store?
No, the food place made the bump out, but the bump out was made with alterations which were subject to review by the landlord under its provisions of the lease. So it had a duty to see what the tenant was doing and not let him do whatever he wanted and create a dangerous condition.
To the extent that there were no violations placed, is that dispositive in any way?
Well, the violations is whether or not the city ever examined the place and issued a violation. So that's not dispositive of whether or not it violates building codes or was dangerous. The fact that the city never went there, they never went there to see it. But there's a lot of violations. The steps were no good. There was a missing handrail. It was in disrepair.
But those are not an issue, right?
Well, they didn't bring it up, but it's also one of the other proximate causes which would hold the landlord in.
And your issue is that he got...
The testimony is, and the landlord
on
was
the
kind
head.
of cute on this one, or the tenant, they, after the accident, drew a sign and pretended like the sign was always there. They put hooks there, pretended like the hooks were always there. But we had the pictures. It was kind of simplistic on their part to add this on and think that we weren't going to catch on. And they also added a bar, which if you look at it, is too long for the opening. So what they did is they kind of bent it. But to bend it creates it to dip down. So it wasn't the original bar. The testimony from the Fisher employees is that that bar was never available and no one ever saw it. So they never got to use the bar. This door was dangerous because it was allowed to stay at 90 degrees, and the steps and the handrail was also dangerous.
Thank you.
Yes, thank you.
Columbus Gourmet.
May it please the court, Joshua Hoffman for defendant, third-party plaintiff, Columbus Gourmet. I'm going to start with the landlord's argument, and first I just want to point out my client, Fuman Singh, he testified unequivocally. This business was opened in 1999, and this is on page 619 of the record. He said, "Let me answer. This storefront was there since we took it over." So, meaning the location of the cellar doors next to the bump out has existed since they took over the property. This was an existing condition.
So your client did not construct the bump out?
No, and at the very least, there's a question of fact because my client's testimony is very, very clear on the issue. And the crux of the plaintiff's claim is not so much the design of the building and how there's a bump out of the step and how the facade bumps out, but it's really the location where the landlord decided to put the cellar doors in relation to this step that bumped out. So if we take the landlord's but-for argument, but for the location of these cellar doors, let's say the cellar doors were moved over a little bit to the left as you're looking at the storefront, that right cellar door that ultimately struck the plaintiff on the head would have been able to lie flat at a 180-degree angle, and this accident would have never happened. So this whole argument about whether there's a safety bar or not is really a red herring and is not germane to the determination and ultimately the denial and affirming the trial court's decision.
Why is it not germane to the clearance for the cellar door opening and the bar?
Two reasons, Judge Weber.
The locking mechanism.
First, again, if the cellar doors were in a different location, that cellar door wouldn't be at a 90-degree angle. It'd be able to rest flat with the floor.
But it wasn't. So what? It wasn't. It's in the location it is, and there's a bump out, and there's either a safety bar or no safety bar.
Correct. And the issue of whether there was a safety bar in and of itself is disputed. That's not here in terms of, at issue with these briefs. But second, as Your Honors pointed out earlier on, there can be more than one proximate cause of the accident. And the plaintiff's expert opined that the cause of the accident was the design of the cellar doors. The out-of-possession landlord does not have any competing expert testimony, and therefore I submit that the landlord did not satisfy its prima facie burden. Just if I could move on now to the Fisher Foods argument, a couple of things that were mentioned. First, it was mentioned that the plaintiff at one point testified that he was planning on returning to work in some sort of investments. That's just not accurate. The plaintiff testified at some point, maybe carelessly and improperly, as to a conversation he had with his counsel as to what he may do in the future if there was a settlement or he won money on a verdict in terms of investing the money. That was clear. Second, Judge Weber, you were on the panel in Ruzinski 210 AD 3D 604, and in that case, the plaintiff, there was expert opinion that the plaintiff was unable to work in any capacity due to a traumatic brain injury. And based upon these competing expert opinions, they denied the employer's motion for summary judgment. Here, the employer has not submitted their own expert. They rely really upon the plaintiff's testimony. And the plaintiff, yes, he did go back to try to work, but he ultimately testified he was unable to, and he stopped working. Here, affording every inference against the moving party, so against Fisher Foods, their motion for summary judgment should be denied based upon the testimony and the opinions of the plaintiff's three experts, Pravder, Bhatia, and Krishna, and the lack of any competing expert opinion from Fisher Foods. If there are no other questions, I'll rest on my brief.
Thank you.
As Your Honor had indicated at the very beginning of my statements, there can be more than one proximate cause. If this court were to find that there is more than one proximate cause, that does not preclude this court from granting conditional contractual indemnification to my client. Under the Hoagland rule, when you have a lease, you can still have contractual, partial contractual indemnification, conditional contractual indemnification.
Under your lease, isn't there a carve-out with respect to your the partnership's negligence?
Well, yes,
And
that
so
would
if
be.
that's the case, why would we at this point, or why should we grant conditional indemnification if that's what the lease says?
Because under Hoagland, when you then transfer that risk to an insurance carrier or a third party, then you can have that indemnification provision enforced. So here, you can have conditional contractual indemnification if you're going to say that there's a chance that a jury's going to come back with some percentage against this landowner for a bump out.
Generally, I've seen those on pass-throughs and that kind of stuff. It's not clear to me that I've seen it in situations where there's an allegation that the owner was negligent with respect to the structure of the premises.
Well, maybe not under that specific fact pattern, but the concept itself under Rodriguez and his progeny does allow for this to be done under these circumstances.
But I mean, so it's, I think what we're thinking is that's a situation where there's pass-through liability 100%. But when there's a chance, we generally don't grant conditional summary judgment when there's a negligence trigger and there's a chance that the party seeking indemnification can be held liable for negligence, right?
Well, it would be.
I mean, you get it later on. You're not
it would be
precluded, but why should we do it now?
Well, again, the fact pattern does allow for it, but it would be conditional, and it would say conditional pending the ultimate allocation of liability.
Thank you.
Thank you.
Yes, Roberto.
Good afternoon again. I just want to address two comments that were made. One was, oh, this person tried to go back to work. Mind you, it was for a year and a half at two different jobs, but the reason he stopped was because of his brain injury as well. Again, read just from the plaintiff himself. This is page 132 of the record. Why did you stop working for ECS? The answer was, and again, I'm quoting, because of the neck surgery. My doctor told me he didn't want me working. He wanted it to heal. Which doctor was that? Answer, Dr. Latuga, that's a spinal surgeon. He was asked about the other job, Fisher Foods, and he stated it was too strenuous. What do you mean by too strenuous for you? I couldn't keep up with the work. The work was too much. When you said it was too much, do you mean in terms of lifting or carrying or something else? Answer, lifting, carrying. And then he was asked, was there anything other than lifting, carrying that prevented you from returning to work? Not that I recall at the moment, no. So Mr. Robles Martinez himself said the reason was because of the neck surgery. So any implication that this is somehow because of the brain injury is just not what he said and not accurate.
Counsel, did you, I assume there was an IME in this case and workups with neurologists and all that and other forms of experts. Is there any evidence that supports, expert evidence that supports some of the arguments you're making now?
There is, of course, in fact, a third-party plaintiff who's now disagreeing with me, his own expert.
Your doctors.
My doctor, no, because I don't need that because the plaintiff himself has said, I think I could go back to work, is I went back to work for a year and a half at two different jobs, at least two different jobs.
So
working because
may
of
I
neck-
ask you this, counsel, when the experts did their evaluations and found that he was permanently disabled, did they not have that information?
I don't know what information they had. or
Well,
didn't have,
I
but
mean,
they can't put the horse back in the barn.
no, you might
It
not.
actually worked.
Let me just suggest to you that if they had that information and they came to that conclusion anyway, correct, then you're saying, well, they're wrong because the plaintiff said this doesn't necessarily require judgment.
An expert's affidavit can be rejected when it's contradicted by the evidence. And even if they have that information, if somebody says he can't work and he actually did in fact work and nobody's disputing that. But just one other point on that, because again, we heard the thing, well, it's really misleading that he said, it was a private conversation with his attorney about future jobs. Mr. Robles Martinez, again, himself said, when he was asked, does he intend to go back to work aside from the MTA license? Yeah, of course I want to go back to work. And it was specifically said that he plans to run, quote unquote, maybe run a business where my wife can work for me. There's obviously more to that.
Real estate.
And that's on page 376
Said
of the
it was
record.
he would be interested in starting up a real estate business with his
Correct.
wife. Thank you. Thank you all.
Thank you.
Stuyvesant Town versus New York State Division of Housing. Justice Scarpula is recused on this matter. As I stated previously, if there's a tie, another judge will be vouched in.
May it please the court. My name is Seth Miller. I represent the Stuyvesant Town Peter Cooper Village Tenants Association. This is a case with two issues that both raise plain meaning issues and can be determined just simply by reading the statute and comparing it with what the agency promulgating the reasonable cost schedule did. The HSTPA clearly commands the DHCR to promulgate a list of major capital improvements, listing them by type of improvements, clearly commands the agency to include in that list only those things that are essential for the structural integrity of a building, the energy efficiency of a building.
And clearly commands that the amount set in that schedule will be a ceiling for those items, right?
I was going to get to that, yes, Judge. And it's a ceiling. And the only thing that a ceiling can possibly mean is that costs can't go beyond that ceiling. So that when the DHCR later promulgated regulations that allowed the landlord to go beyond the ceilings, either by getting a waiver or by adding on so-called related costs, they are acting in an ultra-virus way. They're going outside of what the statute clearly commands. Now, I understand that the related cost issue can be tricky because the DHCR can break an MCI into component parts, and each of the component parts can be considered to be an MCI.
And then they would each be in the schedule.
What?
And then wouldn't they also each be in the schedule?
It would have to be in the schedule. It would have to be in the schedule so that, to use my adversary's example, if you are installing a new boiler, the cost of removing the old boiler is a component part. But that is very, very different from saying, as the DHCR did in the initial iteration of its reasonable cost schedule, that while we're on the roof, replacing the roof, we can make repairs to a skylight because we're there anyway, and those repairs suddenly become an MCI and imposed on the tenants as a rent increase, even though repairs don't get you a rent increase.
So
It's a different
if I recall, DHCR was arguing that there needs to be a certain flexibility so that as costs arise or they exceed the schedule, there's the ability to cut people a little slack. You're saying that really has not. Are you saying that has nothing to do with what the statute allows and that they acted ultra vires?
I think the legislature took into account the need for flexibility. The DHCR was never prohibited from enacting new schedules. They have a regulation that has at least one section that we're not challenging, which is that they can revise their schedule. Our contention is that schedule can only be revised if they follow all of the notice and comment requirements of SAPA. But the point is that they have to constrain their flexibility to the promulgation of regulations.
So you're saying that the term of reasonableness, reasonable costs, has to fall within the schedule? Is that what you're arguing?
Yeah, reasonable costs have to fall within the schedule, and if they want to extend some flexibility to a landlord because some new technology has come along, they have to enact a new regulation by notice and comment rulemaking. There's plenty of flexibility to do that. What they can't do is treat some new technology as a case-by-case exception to a standard rule, particularly not when, we all know how to heat a building. You use a boiler, and if somebody comes up with something that costs 5 times as much, like a nuclear technology using a nuclear reactor, you don't impose that on the tenants just because the landlord paid for it. There has to be notice and comment rulemaking because the public policy issues, not the legal argument about whether it fits a definition or not, public policy issue about whether it's reasonable to make somebody pay for the more expensive installment as opposed to the cheaper
Going back to your point's well taken, but going back to the example, which I think is more realistic, is removal of the boiler. Incurs a cost. That incurs a cost, and maybe their cost to the floor because bolts were taken out, et cetera, et cetera. So you're not disputing that those kinds of costs, which are completely related to schedule MCI work, is recoverable. Are you?
I'm not disputing that. I do
But you're
think
insisting that they should be in the cost schedule.
I just think it ought to be in the cost schedule, and I do.
But how do you put that in the cost schedule with respect to that additional work relating to the boiler? I mean, how do you do that?
Well, what you do is you say the replacement part is X, the labor is Y, the removal is Z. And I gave this some thought because there's not a lot of guidance here. The standard, I believe, is it a component part of the MCI? A component part such as replacing the boiler, such as hooking up the boiler, such as pulling a permit. I see my time is up.
Yes, you have time on rebuttal.
Okay, thank you, Judge.
Good afternoon, and may it please this court, Anthony Radawatso on behalf of the Division of Housing and Community Renewal. Let me dive right in. First, to address this idea that the schedule could accommodate these sort of situations, case-by-case situation, petitioners are wrong to suggest that the agency was required to exhaustively list every conceivable MCI on a single schedule without providing any flexibility to account for unavoidable fluctuations of cost or emergency situations.
Isn't that subsumed by the term reasonable costs?
No, it's not actually. So I want to clarify. The legislature didn't command that the agency simply make a schedule of costs. They were required to make a schedule of reasonable costs, and costs would not be reasonable if the schedule was unable to accommodate emergency situations or unavoidable.
But DHCR can issue bulletins if it turns out that there's a technology that it hadn't anticipated and can set a appropriate cost for that. I'm having trouble understanding how your interpretation doesn't contradict the statutory mandate that DHCR establish a schedule of reasonable costs for major capital improvements, which shall set a ceiling for what can be recovered. It seems to me that you're suggesting that notwithstanding the list, they can approve anything else if they think it's appropriate.
These two provisions here are meant to apply to emergency situations or where the cost at issue is too individualized to list on a schedule. I'll give you an example. So a boiler dying in a cold snap in the dead of winter, or a global supply chain crisis that makes a roofing project much, much more expensive. These are short-term fluctuations in cost.
So in other words, what you're saying is that you can go over the ceiling, theoretically.
Well, no, you can determine the ceiling in two ways. There is a schedule that lists a hard cap on these 200 categories of MCIs, but the department has an individualized process for this narrow category of MCIs.
And what in HISPA permits that? I understand that was the practice before, but what under HISPA permits that individualized process? Tell me where it is.
Nothing in the statute itself prohibits a waiver.
So why is it that you can act regardless of the statute? Isn't that the definition of ultra vires?
Because the agency here had to reconcile two things, both the need to create a cost schedule that provides these, but also does accommodate this flexibility, because as petitioners—
But what in the statute gives you the authority to impose flexibility that the legislature didn't give you?
Because both subsections A1 and 2 required the agency to establish the eligibility for an MCI, and those costs need to be actual, reasonable, and verifiable. That subsection would have—
Those costs are, I understand, but your mandate from the statute was to establish a list of costs, which would be a ceiling. So what under that statute permits you to do an individualized assessment and permit other costs which are not in your schedule?
Well, I think it's important to keep in mind the context here. The agency—
No, I'd really like you to address what in the statute permits you to do that.
The answer is that the only way to do this, to come up with reasonable costs for these MCIs that accommodates these types of situations, is to have a waiver provision.
Okay, so there's nothing in the— so I interpret that as there is nothing in the statute which supports your interpretation, right?
Reasonable—
Can you show me? I'm asking you again, if you could show me what in the statute supports your interpretation.
Reasonable cost, that term reasonable by necessity requires this type of waiver provision.
So, counsel, your adversary says as reasonable cost falls within the definition of whatever is articulated in the schedule. However, if there was something additional, as in I'm fixing the roof, and guess what? Now I'm going to fix the HVAC, and let's take an HVAC. Right. An HVAC, and an HVAC is not within the schedule, then that is not a permissible MCI that would be passed along to the tenants. You know that anybody dealing in an agency hates the term ultra vires, but how is DHCR not acting ultra vires by saying we can grant waivers, we can do forgiveness, we can do all of this, even though the statute didn't say this? That's what the legislature really intended to do. You know that parsing out a statute requires oftentimes recourse to legislative history. Where in the legislative history of the HSTPA does it say that DHCR has the authority to go this far?
Two things, Your Honor. The legislator, they directed the agency to create these regulations. They did not prohibit a cost schedule, or excuse me, a waiver from that schedule. That is a common practice.
You're equating a prohibition, the failure of a prohibition with an authorization.
Right, that's what I was saying. That's how you're reading it. You're saying because the statute did not specifically prohibit it, that means that you're permitted to do so. And I'm not understanding why you're I'm not understanding the basis for that interpretation.
Sure. As the expert agency involved with administering the rent stabilization law in this highly technical area, they were allowed to fill in the gaps. The legislature charged
You're
them.
not filling in the gaps. You're creating a new process that's not permitted by the statute.
It is the
Filling in the gaps I agree with you about, but I don't understand how you can create a process that's not permitted by the governing statute.
Can I answer that question,
Please.
Your Honor? The only way, again, to reconcile the possibility of a reasonable cost with the command of a schedule while accommodating these types of emergency situations, a boiler dying in a cold snap in the middle of winter, a global supply chain crisis that makes expenses more expensive. The only way to accommodate that is these types of provisions. The legislature required the agency to assess these applications on an individual case-by-case basis. There are guardrails in place to ensure that all of the statutory criteria are met.
What are the guardrails in place?
Absolutely. So for each cost that does fall into this waiver provision, the applicant needs to explain the expense, is how it's necessary, and the basis for the request, provide an itemized list of the work, certify that there was a competitive bid process, and provide a certification by an engineer and an architect that explaining the costs and why they are reasonable.
Can the work go above the ceiling under these circumstances? The recovery could theoretically go above the ceiling, correct?
If they go through this process.
Let me stop you there for a second. So it can go above the ceiling. What in the statute allows that?
So it allows, again, this is the only way to accommodate this idea of reasonable cost, because if you
But
have...
that's what the agency determined. Certainly that's not what the legislature was saying, correct?
But I think the concept of schedule here imports the agency's history, which is when you have these schedules in the reasonable useful life context, for example, the agency has applied waivers. So have other...
That was under the old statute, and that's one of the reasons this statute was adopted, as I understand the legislative history, was that the legislature didn't want there to be any further waivers.
The old regime was entirely different, where costs were approved based on actual costs. Here, again, there are significant guardrails that keep these applications...
I know you keep saying that, but why is there a ceiling if you can go above that ceiling, but that is not anticipated in the statute? That's what I do not understand.
This waiver provision that we're talking about
It
here...
just seems that the statute is silent, and you're, as my colleague said, you're not really filling in the blanks. You're creating your own provisions. You're creating your own amendments to the statute.
The ability to do this was embedded in the concept of reasonable cost and the concept of a schedule, because that...
Okay, so is there anything in the statute that gives you that authority? Is there anything that gives you the authority to, again, go above the ceiling?
Subsection A directed the agency to promulgate regulations here, but also subsection A2 required that the agency do an individual...
Under the new statute?
Yes, an individual assessment for each application and establish the criteria for MCIs.
I guess the problem here, counsel, I guess the problem here is that, you know, an owner can make improvements, but if an owner wants to make improvements that are essentially subsidized, passed along to the tenants, then there's certain criteria that have to be articulated, and there has to be an opportunity to object to those criteria and so on and so forth. I mean, that's what rules making is, right? That's what statutes are about. That's, I don't understand you.
So just to be absolutely clear, for the waiver provision, tenants do have they have an opportunity to object. They have an opportunity to object to every single application for an MCI that is under this new regulation. So in addition to the safeguards that I was referring to earlier, the division reviews every single application for an MCI under this new regulation to ensure that it is actual, reasonable, and necessary, and meets all of the statutory criteria, including that it is necessary for the building.
Except for the criteria that it be below the ceiling. I mean, that's the only, and which is probably the reason why the statute was passed, because there was a belief that there was abuse in the past.
I don't agree with that. The statute was passed to retain the MCI program because, for example, you know, the legislature wanted, you know, property owners to take on these types of projects, right? They just wanted to put reasonable checks in place. Those safeguards are...
No ceilings in place?
Certainly it's ceilings, and the regulation contains ceilings. Again, there are 200 categories for MCIs where there is a hard numeric cap. These situations only apply in emergency situations where there are...
Say that in your regulation, that it only applies in emergencies? I've been reading it and reading it. The waiver provision says does not include the word emergency.
So the categories of waivers are listed in subsection F and H and G of the regulation. It talks about basically 4 situations where a waiver applies. These are emergency situations. It's where there's a landmarked building. It is where a work at a building is supervised by a government agency. And there is a catch-all provision that applies to unavoidable fluctuations of cost. You need to show an undue burden and that the work will benefit tenants.
You know, Council, DHCR has so much discretion available to it.
Yes.
I mean, you are arguing essentially for an expansion of that discretion, aren't you?
I don't think so at all. This fits well with the Court of Appeals case in matter of Ansonia Residents Association. There, the Court of Appeals said this expert agency in highly technical areas, including the MCI area, they have the ability to fill in the gaps of the statute, and their interpretation of the rent stabilization law is owed deference. No more is required to affirm on this.
Excuse me, you're on the deference issue. I accept that we, in certain situations, we defer, but we're talking about statutory interpretation here. In that situation, are you entitled to deference?
Yes, in this area.
Even in a situation where we're interpreting a statute?
Yes, and again, that's the matter of Ansonia Residents Association case. The Court of Appeals said in these highly technical areas, specifically dealing with MCI, again, we're talking about, a boiler heating system dying in the dead of winter and how much it costs to remove that from a landmarked building. That is a highly individualized assessment. We're talking about situations where climate change has resulted in flooding in basements, and property owners need to invest in new types of technologies to redirect water from ground level units. These are highly technical areas. Listing all of that on a cost schedule is incredibly difficult to account for all of these fluctuations. The agency determined in its expert determination that the only way to do this, to fulfill the legislature's commands while imposing reasonable costs on property owners so this type of important work will get done, is to have these sort of safety valves in place.
Thank you.
Thank
Any
you.
more questions? Thank you.
I don't have much.
Is your adversary correct that we should defer to DHCR in this instance because they are the agency with expertise to make decisions on these very technical issues?
No, the Kurzich case just comes to mind off the top of my head that the statutory interpretation is for the court. I mean, there's going to be some deference if this regulation is struck down and they replace it with a regime where the only increases come from the reasonable cost schedule. When the agency, for example, says X is the cost of a boiler and Y is the cost of pulling the permit and Z is the cost of removing the old boiler.
What if in that instance there's asbestos? And the asbestos remediation is very expensive and it's not uncommon. So what happens in that situation?
Asbestos removal is on the list. My only suggestion would be that it's the type of improvements that require asbestos to be addressed should be listed. If it's a component part, that's a standard I'm suggesting, but I think it works. If it's a component part of the MCI, yes, it should be in the regulation and it should be granted.
Council,
if it's not a
does
component part, if it's just
DHCR have the ability to amend the schedule so as to include additional items? I was struck by the argument about solar panels. We have climate change, and you're working with
Of course, they're committed to doing this every year, but they're not doing it in accordance with SAPA. Notice and comment rulemaking, this is the second point, which we really haven't discussed, requires that, and I know there are no cases on this, but it requires that an agency that's relying on cost studies summarize those studies well, the statute says explain how the studies are used. And the way I would suggest that be interpreted, again, we're writing on a clean slate, there's no cases, is that if the agency is drawing a line between reasonable and unreasonable, they should say with respect to the data set, where that line is being drawn. Are you drawing it at the mean? Are you drawing it at the median? Are you drawing it at 75%, at 80%, 90%? What do you mean by reasonable? Do you mean reasonable is what two people of equal bargaining power in a market negotiate at arm's length? Or do you mean not insane, which is what it appears DHCR means by it?
Thank you, counsel. Did you have a question, Judge Esper? Thank you. Thank you both. Thank you. Atlantic Center Fort Greene Associates versus the City of New York. Yes, you may proceed.
Your Honor. May it please the court, Jameson Davies for the appellant. This court should reverse Supreme Court's decision and grant summary judgment to the city. The lease and the law preclude Atlantic Center's attempt to purchase the city's property worth hundreds of millions of dollars for what amounts to the price of a Manhattan apartment. The mayoral authorization required by GML 507 shows that Atlantic Center
Can we get to the specifics here? And this is in terms of determining fair market value, the purchase price. How do we give effect to the provisions in this lease if we were to accept your argument?
I think reading the lease as a whole requires the conclusion that it is 150% of current fair market value. The only way to get to Atlantic Center's argument, to get to Atlantic Center's conclusion that you go back to the initial fair market value is to read Clause A to apply here, but it has to ignore three things. One, that Clause A refers to a time after reappraisal date. Two, that the next section of the lease specifically refers to Clause A as covering a 6-month period, not a 25-year and 6-month period. And three, that the purchase option language says fair market value in lowercase, and the cases which they haven't refuted say that you have to give it its reasonable definition if it's in lowercase.
So just based on what you're saying, isn't there an ambiguity in the provision?
I think there's a gap in the provision, certainly.
Well, call it what you want, but maybe there's a contradiction in the provisions, but isn't that something then for the trial court or for a trial to attempt to discern the intent of the parties, and maybe then you're correct. You can look to the disposition and say, well, actually what the parties really intended was a current fair market value.
Sure, Your Honor. I think at a minimum, that's right, that there is an ambiguity, but I think that reading as this court's cases have held, you have to read all the documents as a whole in light of the background principles and try to interpret what the parties' intentions were. And I think when you look at the lease as a whole, combined with the mayoral authorization, combined with the requirements set forth by state law, there's no possible argument that it can be other than 150% of fair market value at the time of the purchase options exercise. There's really no response to the fact that the mayoral authorization says then fair market value after the 10th anniversary. That then can only refer to at the time of the purchase option is exercised. So the extent that there is a gap in the sort of the two clauses that we've been talking about, that gap is filled in by the rest of the lease, the 12.2 and the mayoral authorization, the public notices, which say that in no event can the price be less than fair market value at the time of exercise. There's never been any response from Atlantic Center on that in no event language. They haven't given any explanation as for what it could mean, other than the fact that it cannot be lower than fair market value at the time of option exercise. So there's really, if you look to all of the lease itself, including the purchase option provision and the other provisions, as well as all the accompanying documents, I think it only goes one way. But at a minimum, Supreme Court erred in granting summary judgment to the
Counsel, could the lease be modified unilaterally via an authorization?
Well, it couldn't be modified from the authorization. The authorization predates the lease. The authorization has to happen before the parties can even.
Did any document modify the lease subsequent to its signing?
Subsequent to its signing, I don't think a subsequent document would modify the lease, but I think the mayoral authorization is part and parcel of the lease for a few reasons. One, we cite all the cases that say all these documents executed roughly contemporaneously should be read together. Atlantic Center never offered.
Well, there are references also in the lease to the disposition.
Correct, Your Honor.
Correct. The reference in the lease to the disposition, which the mayoral authorization is a part of the disposition. And even below, Atlantic Center didn't argue that the mayoral authorization was not to be read in conjunction with the lease. That's an argument they've only made for the first time on appeal.
It just seems that 12C of the lease gives the tenant a back door to hold on to the original price as opposed to the original fair market value as articulated in 12.2E. It gives a tenant a back door, doesn't it? You give notice 6 months before a reappraisal date, and you get to keep the original fair market value. You're in.
Well, to be clear, Your Honor, the language says if you give notice not later than 6 months after a reappraisal date. So there has to be, they don't read that section part of the language, but it has to be after a reappraisal date. And that's confirmed by the next clause, which says...
And reappraisal date is a defined term, correct?
Correct.
So what's definition of reappraisal date?
So a reappraisal date, the way the appraisals work is the first appraisal date is 25 years after the rent commencement date.
It's not the first, in other words, it's not the initial appraisal date.
Right, exactly. And I think that's telling because Atlantic Center has to read that language to say, oh, actually, it means the first appraisal date and also all the reappraisal dates. But the language clearly doesn't say that. The lease uses those terms differently in different sections of the lease where they meant to do so. So I think that you can't just substitute in, as they do, saying it can be any time before the first reappraisal date or 6 months after every subsequent reappraisal date. It doesn't, there's no way to read the language to say that. And reappraisal date, so the reappraisal date would be, the first reappraisal date would be 35 years after the rent commencement date, because it's 25 years for the first appraisal and then 10 years thereafter. So I think, all of that language together shows that the only plausible way of reading this is consistent with the mayoral authorization, consistent with state law, consistent with the public notices, consistent with the memorandum of lease, to require that if...
But that, counsel, that only gets you so far. Then you also say, and not only that, but here's how I want you, Appellate Division, to value the property, right?
No, we're not arguing that the appellate...
Yes, you're asking that it's a separate appraisal, that everybody knew it was going to be a I mean, I don't know that fair market value meant that. Did you put in any evidence with respect to that?
No, our argument is that if we win here and they elect to exercise their option, that it should go to the appraisal as provided for in the lease, in Article 33 of the lease. We gave them an offer that we would have been willing to execute the option on consistent with the lease's terms, which required us to do that. But our argument is that if they elect to exercise the purchase option, it goes back to the appraisers. There's a specific procedure for how that appraisal is done.
Thank you.
May it please the court, Janice McAvoy, on behalf of the respondent, Atlantic Center. Turning to the lease language and the question that you asked, Justice Singh, 12.2 C1A, let's call them A and B so I can remember.
A and B is good.
A says there are two time periods, right? And how you determine what the purchase price is.
But focus on my concern here, because it seems to me that Supreme Court conflated the first appraisal with a reappraisal date. Those are different terms.
Well, Your Honor, they are, but the first appraisal, recall, was in 1995. That was the first appraisal, which set the initial fair market value of the land at $3.4 million. That's the first appraisal. The section E, 3.2E, where it defines fair market value, it says, for the fair market value for the period commencing on the date hereof and continuing through the day before the 25th anniversary of the rent commencement date has been appraised at $3.4 million. And why does it have that language? Continuing through the 25th anniversary. There's no reason for that continuing for 25 years to exist unless the initial fair market value, that fair market value, is fixed for 25 years. And the reason for that is when you go to 12.2A, A says if it's, and my friend elides the two phrases in A, right? It says if it's not later than 6 months after a reappraisal date. Is it 6 months after? No, it's not later than, it is before. And therefore, you go back to 3.2, you go back to that initial fair market value that continues for that 25 years. And with respect to your specific question, Your Honor, the first appraisal was that 1995 appraisal that set it at 3.4. It then says, you know, the first appraisal date is the 25th anniversary, each a reappraisal date. But it then goes on to say, and this is the next sentence that's on page
When was the first appraisal date? Wasn't it 11/1/21?
That was for the first reappraisal, Your Honor. And what the lease says is all reappraisals of the land for the periods commencing on or after the 25th anniversary of the rent commencement date shall be based on blah, blah, blah. All reappraisals starting in 2021. And the reason that it's a reappraisal is because the land had already been appraised at $3.4 million. So that first reappraisal date is that first reappraisal in November 2021. And Your Honor, the city's reading makes no sense. It creates a gap.
Wait. And you're saying that your reading is that 25 years later, you could buy that property for the fair market value that it was for 25 years prior to that is a better reading of the contract?
Absolutely not, Your Honor, because that wasn't the purchase price. The fair market value of the land is one component of the purchase price. The purchase price is 150%.
Okay, let's just put it in perspective. What are you claiming today is what you should be able to purchase the property in Brooklyn for?
A little more than $11 million.
$11 million. What is the city claiming is the fair market value of that property today?
I don't know what they're claiming.
You know what they're claiming.
They're saying it's in the hundreds of millions, Your Honor, but...
$600 million,
that's
correct? And there's an appraisal that backs it up.
No, they do not have an appraisal that backs it up. They have opinions of value from 3 different appraisals. They're one page
Okay, so
each.
wait, when you say they have opinions of value from appraisals, that sort of means they have some appraisals,
They have
right?
one page from an
Okay.
appraiser.
So
It says
yours-
$400 million.
May I just finish my thought? You're saying that your interpretation of this 99-year lease with option to purchase, which is 25 years in, you could buy the property for $11 million, is a more reasonable interpretation than the city's interpretation of the lease, which, according to their appraisal, is worth $600 million.
Your Honor, their appraisal is not $600 million.
That's basically what you're telling us,
They're-
right?
they're-
That
they're-
we should accept that this property, 25 years later, without any appraisal on your part, is worth $6 million.
No,
$11 million, I'm sorry, right.
Your Honor, there are multiple components of the purchase price.
We're talking about, no, let me...
Well, then the fair market
Well,
value
yeah,
is
that's the
$400
component.
million.
That's the component. And the initial
to the
fair market value was 3.2 million?
3.4.
$3.4 million. So essentially what you're saying is that you're entitled 25 years later to an initial fair market value of $3.4 million.
Absolutely, Your Honor. And by
After
the way,
25 years.
after 25 years, there was...
Because there's no inflation or increase in the value of property in this section of Brooklyn, which is Barclays, right? There has not been any increase or anything of that nature. The numbers are stagnant.
Well, Your Honor, a couple of things.
And that would be a reasonable interpretation of the intent of the parties in 1995 when this contract was drafted.
Yes, Your Honor. And the original developer who entered into the lease with the city went to the city in 2014 and said, this is how we negotiated this lease. We negotiated, and this is what it says, that the purchase price is based on 150% of $3.4 million. And what did the city say? EDC said, we agree with you. The internal emails, and they're cited in our brief, the internal emails from EDC all say, the developer's right. That's how it's read. And the city carried it on the budget.
But there
years.
cannot be a change in position in those 10 years.
Well, Your Honor, they carried it consistently for we know 7 years. I don't know what they were carrying it before that, but for the 7 years after this issue was raised until this litigation happened, they carried it at that $3.4 million. Because reading the lease discussing it with the negotiator of the lease, the developer, they agreed that there was an intention to incentivize the developer to exercise first to spend tens and tens of millions of dollars to redevelop this area. And the reason that it's now a nice area in Barclay Center is because Forest City, the original developer, spent hundreds of millions of
Because
dollars.
the Nets are winning. Justice Gonzalez has a question.
Quick question.
They lost.
Are you really not paying any rent?
Oh, no, we're paying rent, Your Honor. We're paying rent based on based on the stipulation that we entered into with the city.
Thank you.
And Your Honor, the one last point is there was an intention to incentivize this developer, to incentivize them to exercise the purchase option within the first 25 years.
That's right. I stand corrected. Liberty did win. So, yes, thank you.
It was a great game in overtime.
It was a good game. I
was a
completely
good game.
forgot. I'm sorry.
It was a crazy
I
game.
apologize. That alone is worth the $11 million.
Just to go to the last point about the incentives, that's just a terming argument. There's nothing in the record that suggests.
But those are issues of fact for trial. So, go back to really the technical argument about a reappraisal date and what that means, because your adversary says essentially that this gives them the right to do it in terms of getting the 3.4 million. Aren't there easier, if this is what was meant, couldn't they have, for example, just put in at the initial fair market value?
Correct, exactly, Your Honor. Initial fair market value is a defined term which the purchase option provision purposefully does not use. If they meant to refer back to initial fair market value, they could easily have said that. They could say at 150% of initial fair market value, which is a defined term in section 3.2 of the lease, but they didn't do that. And so I think that makes it clear that there's no intent to reference initial fair market value.
And let me just ask you, at the time that the mayor put out the sort of request to the public to comment on this, did the mayor say, and this developer in 25, 50, 75, however many years, gets to buy this property at $3 million?
No, Your Honor. I'll say exactly what the public notice did say. The developer shall have the option after the 10th anniversary to purchase the premises at 150% of its then fair market value.
Then fair market value.
Which in no event shall be less than the premises market value plus the city's capital investment.
So what the mayor is saying to the public is, my understanding of the deal is when they exercise the option, it's 150% of the then. Correct?
Correct. That's what the mayoral authorization says. That's what the public notices say. There's never
The problem is the lease doesn't say it.
Right.
The disposition says it.
Right.
So then the question is this an issue for trial, for the trial court to discern the intent of the parties?
Right. I think because this is a unique situation that's governed by GML 507, the lease, by law, to be valid, has to be within the bounds of the mayoral authorization. There's a bunch of cases we cite that say GML 507, it's the font of authority for entering in the lease. So if you...
Let me just ask you about the tax question. Council says that was carried at a fair market value of $3 million for forever and ever. What's your response to that?
A couple of responses. One, I think it's a mischaracterization of the record. If you look at page 447, they say it's crystal clear that the option goes our way, not their way. That's the emails that they're talking about. But two, what we testified to, or what we put in a declaration that said that where there is a dispute, EDC values the land at the lowest possible outcome it's going to come just for its own budgetary purposes. There's no argument that EDC doesn't in fact do that. It's just that that's how they do their budgeting. And just if I could just a couple quick points, there's just a couple things that, they've had a long brief, they've had argument, they've still never responded to. The fact that Clause B refers to a 6-month period, not a 25-year and 6-month period. The in no event language we were just talking about from the public notice, and the use of the lowercase term instead of referring back to the defined terms and fair market value. And even their own expert has said the lease can be read in the city's favor.
Thank you.
Thank you, Ron.
Lauren v. Hotel, Pennsylvania. There he goes. You're getting like Jeff.
Good afternoon, Your Honors. May it please the court, Michael Zhu, Appellate Counsel to Rimland and Allers, attorneys of record for the plaintiff, Grace Lauren. The lower court's order should be reversed, and the defendant's motion striking the plaintiff's op papers as untimely vacated, because I'm not here to argue that the plaintiff's attorney was correct in just filing papers on the eve that the reply was due. He's absolutely wrong in doing that. And my adversary here is going to get up and say that court orders are sacrosanct. I totally agree with that. Under Gibbs and Brill and Maselli, orders have to be obeyed. But I think the issue here is a little nuanced, because although the papers were late and he should have asked for a third adjournment, and if he had, it would have been either been granted or denied, but we would be in a different position. But he didn't. And instead, he just filed it. But I think the sanction of striking the papers and dismissing the claim because the summary judgment motion was unopposed is a little too draconian in terms of the end result here of the plaintiff not getting her day in court. And you don't see the lectern, but I'm on my knee pads, I'm on my hands and knees here. What it really comes down to is, and there's an old phrase from the third department case that talks about a malpractice action against an attorney is sometimes not a sufficient alternative. And I think that the better alternative here would have been, and I asked this court to exercise its own discretion in just simply sanctioning the attorney for not filing his papers on time. This is an issue that he will never forget. I'm not excusing what he did. Obviously, the better course would have been to ask for an adjournment, and for doing what he did.
Were sanctions even an issue?
It was not, but I'm asking this court to exercise its...
Oh, you want us to sanction the attorney?
Yes.
What?
Well, I mean, for not filing his papers on time and not complying with the so ordered stipulation.
I don't know that we have that authority, but sure.
But I'm asking.
Okay, we can sanction you as well, but. No?
If it helps my client.
If it helps your client, we'll
If it helps my
sanction you. We'll
client.
just sanction everybody.
Again, Judge Weber, you don't see my knee pads here.
I mean, while you're there, we might as well sanction you as well. Thank you.
Good afternoon, Your Honors, and may it please the court. My name is Ellen Wilder, and I am here on behalf of the defendants in this case. Truthfully, I don't have much to say.
Counsel, I have a question to ask, which has to do with prejudice. Where is the prejudice, understanding that the adjournments were secured so as to allow the plaintiff to obtain the report of its home security expert? Is that what they called him? Yeah. Mr. Bonelli? Mr. Bonnell? Where's the prejudice? As soon as it was received, as soon as that report was received, long time after it was requested, counsel filed the op papers that very day.
Well, he did file it that day, but we don't know what time it was received. The counsel did not reach out to me asking for an adjournment. He did not reach out to the court, and he did not say in any of his letter in opposition. I'm sorry, what?
How were you prejudiced?
Well, I was prejudiced because first it was filed at the eve of the return date. I was not able to.
I mean, you could have gotten more time to put in your reply.
Well, the lower court had its discretion, but we are prejudiced in that there was, and with all due respect, it is our position that prejudice isn't a requirement in this case, but we are prejudiced in the sense that it's now been a year and a half, 2 years, time and expense has been shown, and the hotel is now no longer in existence.
If there had been an extension, that would never have happened, and you would have been done long ago.
Well,
that was to a certain extent your choice.
Yes, that is correct, Your Honor. But the lower court
caused your own prejudice.
What?
So you've caused the prejudice in part.
How did we cause the prejudice? I'm not understanding.
By pressing this issue instead of letting those papers be accepted.
Well, I wrote a letter to the court explaining that we are prejudiced for the opposition being filed at the eve of trial and asking to either be stricken or, in the alternative, to give us an extension of time to answer. The judge, the trial court, within their discretion, decided to
Oh, so would,
Strike the, just
would-
strike
isn't
the
that
opposition.
an improvident exercise of discretion there? And
By the
not
court.
giving, by the court, and not giving you actually an opportunity to put in reply papers, and then, most critically, to all of us in this room, that matters be heard on their merits?
Well, I don't believe so because the decision was actually made on the merits. There was a 6-page decision thereafter, which is not before the court, where they did have to find that we had to meet our burden.
So, counsel,
I'm sorry, repeat that?
I'm saying that the decision was, while the summary judgment decision in and of itself is not before the court, it's only the order to show cause,
Yes.
striking the opposition, the judge did say in the later decision, which is in the record, that we're not just granting it on default, we are deciding whether the defendants met their burden.
I was going to ask you, to the extent that you were disrespected, and I'm going to use that word, and it's a strong word, but to the extent that you were disrespected because the regular course of action when an adjournment was needed was not followed, to the extent that the court was disrespected, to the extent that leave of court wasn't requested, right? Wouldn't or could a remand for compensation for your time and effort and ability to put in a reply ameliorate all of this so that the case could go forward?
Well, that is an option. I'm not saying no, but I think that the rules of the court and the rules of the CPLR and the rules of the judges have to be respected.
Yeah, but
And the-
but the thing is, right? Yes, of course.
Mhm.
But why does this plaintiff have to suffer because her lawyer was disrespectful, right? Wouldn't it have been better, or wouldn't it have accomplished what you want to accomplish, to have some sanction, but not? I mean, this is not, the plaintiff's been litigating this case. This was not an unlitigated case where you served a summons and complaint and nothing happened for 4 years and then you move for a default judgment, right? This plaintiff had been litigating this case. So can you see where it might have been a better course of action to sanction the attorney who clearly did the wrong thing, but not put that on the plaintiff? Okay.
I
mean, it's a
kind
little
of
rhetorical.
rhetorical. No, I understand that, and the
Thank you.
plaintiff does have action against her attorney.
Thank you.
Great.
You have nothing further, do you?
No, I do not.
Gamma V 2000 one-story tower. I'm sorry, AC 31 versus Fowler. Apologies.
Good afternoon, Your Honors, and may it please the court. My name is Erin Flynn for Melissa and Mark Fowler. This is just on the judgment of foreclosure and sale.
So what evidence was submitted by your clients concerning the calculations?
Concerning the calculations?
By the referee, yeah.
For the referee, for the specific part of being sold in
Yes.
multiple parcels, there was no evidence submitted by our client that it was being sold in multiple parcels would raise a higher price. However, that still doesn't mean that the referee's determination that selling the 4 condo units as one parcel.
Was there any evidence that the referee could rely upon in making the determination that it should be sold as a single parcel as opposed to 4 parcels?
Right.
The plaintiff claims that the referee relied upon some evidence. There was evidence submitted by the plaintiff. However, the referee's report doesn't state that was relied upon. The referee's report instead states the property description was relied upon.
So I guess my question should have been, what evidence was put in by your client which would dispute the determination by the referee based upon what the other side put in?
There was no evidence put in by our client regarding that.
How do we review your argument properly? This is a duplex apartment made up of 4 units. It's got 5 bathrooms, 5.5 5 bedrooms, 5.5 bathrooms, 1 kitchen, 1 main living area, and and no determination as to the feasibility of how you divide what was 4 units back into 4 units.
4 separate units.
4 separate units. How do you expect us to analyze this?
So we actually do find that there should have been more of a determination. And I wish we had done more of a determination, but regardless of that,
But in the
property
absence, what was the
description.
court supposed to do if you didn't give them anything on which to base a determination?
Well, if the referee had actually referred to anything to base the description. the
Referee referred
determination
to
on the-
common sense, right?
He just said the property description and wasn't clear even what property description.
And what case is there that requires a list? I specifically relied on this. I didn't see any. Certainly, trial judges often say based on the record and not a specific document or a specific testimony. So where in the law is your requirement that the referee say, and I relied on this, as opposed to here's the record and here's my decision?
And at some point, the referee does say, the Fowlers have not objected to the plaintiff's calculation. Well, this was as to the escrow advances, but I therefore accordingly report that the advances are $76,000. I mean, the referee does state that your clients did not produce anything.
Correct. We did object and tried to fully litigate it, but there was no separate appraisal presented.
Could you address oops, the red light came on. I'll ask my question later.
Thank you. Yes.
Thank you. May it please the court. As far as the referee's report goes, the referee's report states at page 248 that the referee reviewed evidence, parentheses, set forth below in the report, and then among the evidence that's set forth below in the report, in particular page 249 to 250, is evidence supporting the referee's single parcel determination, most notably the affidavit of Mr. Shanamayo, the New York State certified real estate appraiser with experience appraising the particular type of property at issue here, improved residential property in Manhattan.
So,
And according to him, he said it would require significant investment of monies and time to physically reconfigure the premises into separate legally habitable units.
That's right. He said that, and there's no professional real estate testimony on the other side refuting that. So really, I don't think the referee had much of a choice.
And he also said it would not be economically feasible, and that the best and most feasible way to maximize recovery would be to sell the mortgage premises in one parcel.
Exactly, Your Honor. I do want to move to the attorney fee issue because I got a
So,
sense
counsel, just one correction on my part. So this was not a question of relying on common sense, right?
No, this was more than common sense. This was undisputed, or at least not expertly disputed, expert testimony. Appraiser on one side, our side, no appraiser on the other. It was
So
just
talk about the reasonable attorney's fees.
Yes, that's right. So my friend on the other side makes two arguments.
Well, they say you did not particularize challenges to the number, you did not particularize the number of hours billed, the task performed, or the rate charged.
I'm sorry, Your Honor, I didn't catch.
They said you did not state the number of hours billed. They said that your billing was conclusory in that you did not state the number of hours billed, the task performed, or the rate charged, right?
Well, our billing was anything other than conclusory. Pages 545 to 804 of the record, which Supreme Court referred to, contain AC 31's affirmation of legal services and approximately 250 plus pages of supporting documentation, including invoices establishing work done, the description of the work, staffing on individual matters, the rates charged, and there's also in the affirmation of counsel below testimony, undisputed testimony about the reasonableness of those rates.
Would it be fair to characterize this litigation as protracted?
I think it would be fair to characterize the litigation as protracted.
And
Your Honor.
the case has been up to the appellate division in the past?
Yes, it has, Your Honor.
And were fees assessed for work in the appellate division done?
Part of this award included those fees. That's right, Your Honor. And my friend on the other side they don't take issue with any they don't specify any particular charge of the voluminous detailed charges that we set forth that they say should be disallowed or reduced. And as this court's case law says, that's a requirement. They didn't do that before Supreme Court. So when we're here analyzing Supreme Court's exercise of discretion, Supreme Court wasn't pointed to any specific charge that my friend on the other side wished to disallow. So for that, and because Supreme Court really gave a thorough opinion, it identified the correct legal standard, the Jordan factors, it identified the pertinent factual evidence to be applied under the Jordan factors, and then it cogently explained its award and reasoning under the Jordan factors. We would ask that the award of attorney fees, as well as the confirmation of the referee's report, be affirmed in the amended judgment.
Thank you.
Thank you, Your Honors.
Yes, Justice Gonzalez had a question.
I was going to ask you, is it correct that no rents have been paid? But I think that's not an issue, is it?
Correct. Rents have not been an issue. Tenants were living there. It is not standard for rent to be paid during a foreclosure.
Thanks.
So do you want to address the attorney's fees issue?
Our issue with the attorney's fees is the standard that the trial court judge used, and a determination that based on the amount of judgment, attorney's fees for 5% of that judgment was reasonable, where that is not the standard. The standard is reasonable and warranted for the services rendered.
So where was the abuse of discretion on the part of the Supreme Court? How did the Supreme Court, because that's the standard, right? Abuse of discretion. So where is the abuse of discretion?
In using the wrong standard to begin with, that she didn't determine that the reasonableness and the warranted needs for the different services provided. Instead, she just made a general determination that
Affirmation of legal services with 250 pages of supporting documentation. That's a lot. Thank you. Thank you both. Gamma v. 2001 Story Tower.
May it please the court, Jessica Smith for defendants appellants. So just briefly, here we're only seeking modification of the Supreme Court order.
Yeah, so counsel, I did not understand your argument. What prohibits you from asserting a defense of comparative negligence?
The court essentially only wrote that they were setting this matter down for a damages trial. So the term damages trial only could be interpreted as ambiguous.
Damages? You don't consider comparative negligence when talking about damages?
I personally believe...
It's been a while since I've done these cases, but I always thought that was a part of damages. Is there some case that I'm unfamiliar with that says that it's not?
Well, if I could just point out that the issue is that this could be interpreted by a trial judge who gets assigned a trial as differently.
Why wouldn't the trial judges interpret it the way you interpret it, the way I interpret it, the way the law requires the trial judges to interpret it? What makes you think that the trial judge is not going to understand that damages includes comparative negligence?
Well, just to say, the risk is too great. It's too great of a...
I'm not talking about the risk. I'm saying what makes you believe that the trial judge is going to get it wrong before the trial judge does anything?
If I could just point out one case where this court had a similar situation, that's the Silverio case, which is there was a summary judgment order granting plaintiffs summary judgment as a matter of law. It went up on appeal, that was affirmed, and then the case comes back up after plaintiff moved for a judgment. He obtained a judgment assessing 100% comparative fault against the defendants. And then we needed a second appeal at that point, and those defendants to then address that issue. And then this is exactly what we're trying to prevent here.
What is it that you want from us?
We essentially want a modification of this order granting...
But why does it need a modification? Maybe a clarification,
But it's not our order. Why didn't you move for re-argument before the trial judge?
We did move to re-argue, and the court denied re-argument, and then in denying re-argument stated that they already said that the comparative negligence would be addressed at the damages trial. However, the order
Right.
never-
So why isn't that clear? That's what the court said. So why is that unclear to why is it unclear to you but clear to everyone else?
Well, I don't want to get into anything that's outside of the record, but if this could have been resolved before us coming here to an appeal, we would have done that. But we're here because apparently.
So you want us to say in the order, you want us to modify to the extent that the trial court shall abide by the law as to comparative negligence being a part of damages. You're hereby directed, trial judge, you are hereby directed to comply by the law as it stands as to damages and comparative negligence.
We're just asking I don't need a directives telling the court to comply by the law other than simply just stating that the trial will include comparative negligence. The court below had the opportunity to simply grant re-argument and make the correction on that motion.
Yeah, I mean, that's the problem. It's not a correction. It's the trial court stated the law exactly correctly.
Thank you.
All right, thank you.
Doxiadis, and I apologize for the mispronunciation, versus Triborough Bridge. How is it pronounced?
Good afternoon, Your Honors.
How is it pronounced?
I'm sorry?
How is it pronounced? I mispronounced?
Doxiadis.
Oh, Doxiadis. Thank you.
Jonathan Goldsmith for the defendant appellants. May it please the court. Your Honors, we have two arguments that we assert on appeal, and I know Your Honors have read the brief. This involves
And the photographs as well.
And the photographs. So you see the delineators on the solid
And the
white line.
delineators and where they were placed, and the lack of any studies as to how they should be placed, et cetera. But go ahead.
Well, Your Honor, I'll start with the MUTCD if I could and leave the studies for later. But the MUTCD is controlling in New York, and it says that a delineator, such as the one used here, can be used to emphasize a line that separates the lane.
But it also said that you have to exercise engineering judgment. And I didn't see anything that showed that you had done so.
Well, as to the first part, yes, Your Honor, it says that. That's the second part of the sentence. So I split it up into, there's two prongs, right? First, is it used to emphasize the lane marking? I think everybody agrees. And then second, and I think this is really the only issue in dispute, is whether there was the use of engineering judgment here and whether we've met our prima facie burden on summary
Right, so
judgment
let's make it easy. Because I looked, what was the name of the engineer with whom you, the TA?
That's not part of the record, Your Honor. And we don't think it should.
It's not there.
It's not, correct.
It's not, but that's the whole point. Not that it's not part of the record. That's the whole point. It's not part of the record, so you haven't met your burden.
Well, Your Honor, I would disagree with you respectfully because
What, you have any reference as to meetings with the engineering department?
there's reference in the
And with whom the TA spoke? I keep saying TA, TBTA.
Yeah, there's reference in the testimony as to the involvement of the engineering department in the
de
decision.
minimis. It's de minimis. There's no specificity. You're asking for the application of qualified immunity. That is one heck of a privilege, right?
Well, Your Honor, this is not qualified immunity. This is simply a provision with the force of law, with the force of a statute, that says if the delineator is used to emphasize the line and there's the use of engineering judgment, you're entitled
Counsel,
to...
we're going around in a circle.
Well,
right? There's nothing in the record to back you up.
I think it's important, Your Honor, to recognize the separation between the immunity argument and the MUTCD argument. It's a statute with two prongs. If we satisfy both prongs, immunity doesn't come into it. It's the second prong that's at issue. And I don't think it's proper under the scope of this statute as it was adopted to require anything more than testimony that engineering judgment was used.
Anybody can say that.
Any evidence of that?
Well, there's testimony from Ms. Shepard that talks about that the decision was made by the operations mitigation team, which includes the engineering department.
But we don't know that they exercised engineering judgment. They might have been involved, but we don't know what they did.
Well,
That's the problem.
She testified that the studies were done regarding motorcycles striking the tubular markers. She did not testify that any studies or investigations were performed regarding the risk posed by placing the tubular markings beginning where the dashed line turned into a solid line.
And Your Honor, this is why I think it's so important to separate the two arguments. We don't have to show that there was a study done.
Well, that goes to your qualified immunity.
The qualified immunity argument, right? So just to put a fine point on.
So you're saying that it's sufficient for her to testify engineering department was involved, and therefore we can assume here that this involved engineering judgment.
Well, she doesn't just say that. She also talks about the things that were considered by the operations mitigation team. She says,
Counsel, you're going off. That's a red herring. Engineering judgment, at section 64, right, of MUTCD 1A.13, engineering judgment shall be exercised by an engineer or by an individual working under the supervision of an engineer, right? So there is nothing in the record that shows that an engineer was consulted other than somebody saying, oh, and by the way, we consulted with the engineering department. No name, no name, no name.
no name is right, Your Honor, but it is more than we've consulted with the engineering department. We've consulted with the engineering department, and this is what was discussed. We looked at accidents, we looked at history, we looked at the use of these
And
markers.
there's no reports as to what was discussed. You talk about those oral conferences, those conferences over the telephone that were not recorded, that there's no documentation.
I'm talking specifically, and by the way, Your Honor, in the MUTCD, it specifically says that the use of engineering judgment does not have to be documented. And I think that...
I see that, but you know what? Speculation is not exactly our cup of tea either.
I understand that.
Is there anything in the record that says that these discussions with the engineers played a role in the placing of the tubular?
Well, she says that the operations mitigation team made the decision, and that
But
is
she
made
doesn't
up of
say
the
that was based upon the discussions with the engineers. And then she goes on at some point to say that the studies were not, the studies did not provide any support or basis for the placement of the markers.
I think, Your Honor, that it's very tempting in a case like this to apply the common law standard, but the
Now, what is tempting is to have a full record of exactly what was discussed, who it was discussed with, and whether or not those discussions led to the ultimate action that took place. Thank you. You have time on me, Bob.
Thank you, Your Honor.
Yes, you may proceed.
Good afternoon, Your Honors. May it please the Court, Christopher Della Carpini for the respondent, Mr. Doxiadis. Just to make clear as to that there was no engineer involved in this decision. Ms. Shepard's testimony is less than clear on the point, but after her deposition, we sought a deposition from the state of the engineer that was involved in this case. The trial court denied this. We discussed this in our brief at page 15, and it's in the record at 686. The trial court denied it, finding there is no indication that the decision to place the subject delineator on the solid white line was made by an engineer, or even such decision was made on the conference calls, although such was discussed. There's no engineer. By their own standards.
Why isn't it sufficient for Ms. Shepard to say we discussed it with various departments and the departments had engineers and engineering judgment was utilized in placing the poles in the manner they were placed?
I don't think Ms. Shepard even said that, Your Honor. When I look at the greatest hits from Ms. Shepard's deposition, you look at page 610. Whose decision was it to install delineators? It was the operation mitigation team. She never says who was on it. She never says that there was any engineer involved in this. When you look at, and they overlap somewhat when we talk about what went on here, the qualified immunity and the negligence standard. They kind of overlap because they all were not proven by the same testimony. She asks on page 620, what type of study was done? Past experience and the use of delineation throughout the authority. Page 621, was there any consideration reviewed or undertaken concerning whether or not a motorcycle or two-wheel vehicle striking a delineator would be upset by the strike.
She specifically stated that none of these studies talked about the placement in reference to motorcycles.
Yes, that's exactly right. And that gets more to the qualified immunity issue. But on the standard of negligence, by their own rules, their own MUTCD provisions, the delineators shall be put in as determined by engineering judgment. And they also expressly say engineering judgment shall be done by an engineer. There's no engineer. There's none in the record. He can, whatever you think Ms. Shepard suggested, we resolve this after her deposition by asking to depose the engineer. And we were denied because the trial court found correctly there was none. Whoever else was on that call, none of them were engineers. Just a few points to say about the qualified immunity issue. First off, it is an affirmative defense. I think the defendant suggests otherwise. It's an affirmative defense that was recently restated by the Second Department in the Chen decision, which we handed up today and sent to counsel yesterday. And what's required is deliberate governmental decision-making, which considered the risks relevant to the action. I think we've covered that already. I'll just point out the defendants rely on the Affleck decision of the Second Department as if that supports what they did. When you compare Ms. Shepard's testimony about this conference call to the proof that was put forward in Affleck, there was an affidavit about traffic counts, a consultant's report, evaluations of accident reports. Affleck only shows how inadequate the defendant's evidence here was. Perhaps some testimony about a conference call could entitle a defendant somewhere to qualified immunity and prove compliance with engineering judgment. It's not on this record. Are there any questions?
No, thank you very much.
Thank you, Your Honors.
Your Honor, I'd like to get into the qualified immunity since we focused on the MUTCD, but I would urge the court that if it finds an issue of fact on the MUTCD, it not impose the common law standard. If the issue is the link isn't there in the testimony of Ms. Shepard, she doesn't specifically say that engineering judgment was used, then that's the ruling of the court, but it should not go further in our...
But isn't that something on which the burden is on you to show that the decision was made was a result of a deliberative decision-making process?
Well, for the MUTCD, we don't have to show that. We only...
No, for qualified immunity.
I'm just saying for the MUTCD,
For qualified
Your Honors,
immunity, you have to show that there was a deliberative process.
Yes, for the MUTCD, the court should not, in my opinion, and we're arguing, it shouldn't require us to go into the issue of what was the judgment? Is the judgment reasonable?
Don't you still have to show that the decision to install the markers were made by an engineer or in consultation with the engineering department?
We have to show that.
She only testified that the engineering department was a part of the team. She never testified that the engineering department was involved in the design or the placement of the markers.
And I'm saying, Your Honor, if that's a finding of the court, I just ask that the court not require us to go further and provide evidence at trial, for example, that the judgment was reasonable. If we can show at trial that there was a use of engineering judgment, we think we have, but if the court doesn't, it shouldn't have to go farther. Who were the engineers involved? What was their judgment? Was their judgment reasonable? That shouldn't be required.
It was your motion for summary judgment, right?
It was, Your Honor.
Okay.
And quickly on to qualified immunity, the Affleck case is controlling here. I mean, it's out of the Second Department, but it's right on point.
What about Leon in this department?
All the cases, including Leon, that are cited by the plaintiff, deal with more general applications of rules.
Well, Leon specifically talks about the lack of study, inquiry, or investigation conducted into the risk posed by placing the tubular markers at the beginning of the solid line.
Your Honor, Leon involved a decades-old memo and an affidavit regarding more general standards. Here, we have specific study, does not have to be written under Affleck. We have a specific study that was done as to traffic control at this location and a determination that was made as a result of that deliberation. And just to close, Your Honor, in Affleck, counsel says, oh, there was a study there. There was a study there.
But I thought the studies that you referred to again spoke about buses and spoke about vehicular traffic and did not address motorcycles.
Your Honor, in Affleck, the study was done by Waldbaums and said we need a traffic light. And the
But we're talking about this particular case. I did not see any reference in the testimony as to studies specifically addressing motorcycles as opposed to vehicular traffic.
Ms. Shepard says that two-wheeled vehicles were considered in their deliberation and that impact between the two-wheeled vehicles, including motorcycles and...
Okay, so here's where we get to the common sense. There's a difference between motorcycles and trucks and buses in terms of wheels and in terms of the tubular setups.
And she said that motorcycles were considered in their deliberations when they discussed this. And in Affleck,
Is that an informal study? That just seems like,
it's an investigation, and that's why Affleck's important, Your Honor, because the study that was done in Affleck by Waldbaum's was set aside by the municipality. They did their own investigation, and all they relied on was an affidavit of someone that they said they said almost the same thing. We took visits, we evaluated accident reports, we performed traffic counts, and based on that, we set aside the formal study that Waldbaum did and followed our own judgment.
That would seem to go against our precedent in Leon.
I think it doesn't, Your Honor, because in Leon, it wasn't specific to the exact issue at the exact place. That was, the Leon court talks about the more general issues. The Leon court also talks about the decades-old memo. This is not a decades-old memo. This is a specific analysis and deliberation about this location, which was having traffic issues, accidents. They looked at this specific location, they talked about it, they figured out what they were gonna do, and they
Didn't have an engineer.
Thank you.
For immunity, we shouldn't need an engineer, only for MUTC.
Thank you. People v. Donald Davis.
Good afternoon.
Good afternoon.
Legal Aid Society by Lorraine Modello, appearing for the appellant Donald Davis. We're asking this court just to correct the illegality in his sentence, which was raised in our 44020 motion.
So is it should we correct it? I mean, do we have the authority to do so, or do we remand for purposes of the trial court to do so?
To just correct the illegality in the sentence?
Yes, or send it back to the trial court to correct any error.
We're asking this court to correct the illegality since it is illegal as a matter of law. We asked the court below. The court below refused to follow controlling law despite the prosecution's concession. We moved to re-argue. The court again refused to follow controlling law despite the prosecution's concession. We're asking this court just to correct that illegality. We believe that's why this court granted us leave to appeal the denial of the 44020. We're asking this court not to grant the prosecution's request and go beyond what was below, what was raised below, and remand the case for a plenary resentencing.
why not? Why shouldn't we do that? Why shouldn't we remand to the trial court? Why should we not remand? Clearly there's an error here, but why should we not? It's an illegal sentence.
And I think the people concede.
Yeah, why should we not remand to the trial court to
correct it,
correct
to
the
resentence?
To do a full
resentence,
resentence?
right.
Or to just correct the illegality?
To resentence.
To resentence. By resentence would correct the illegality.
If the court wants to remand it only to correct the illegality, that's fine. It seems unnecessary since
No,
this
but
court
then
could do it.
let me just interrupt you. If we do that, right, then your client doesn't get the sentence that the trial court intended your client to get, right? So that's why we sent it back for resentence. And the trial court has broad discretion under the case law and the statute to resentence. And the Court of Appeals has even noticed, I should say.
Below would have the ability to do a resentencing if this court ordered it. It didn't on its own. However, this court, as a matter of its precedent, when issues of illegal sentences are raised on 44020, has not remanded for a full resentence. When defense counsel has asked, the cases we cited in our brief, People v. Anonymous, the other cases, they all state, this court just said, we're correcting the illegality. That's what we're correcting.
But that didn't change the overall sentence. If what you're asking us to do would change the overall sentence. In those cases, it was sort of, the sentence remained the same at the end of the day. But what you're asking us to do would change the overall sentence.
What we're asking the court to do is what is before the court on a 44020.
Am I correct that you are asking us to change the overall sentence?
At the times when
it's just really yes or no.
When we're asked, the aggregate sentence would be different, yes. But the prosecution had the ability, at the time that the 44020 motion was made, the prosecution had the ability to ask the court, if you're talking about we weren't getting the benefit of our bargain, the originally agreed upon sentence, the remedy which was available from People v. Laureano was for the prosecution to say, we want the plea back. You're not giving us the benefit of the plea. We're asking this court to vacate the plea. The prosecution below specifically said no.
So you're stating that the prosecution, by doing that, has somehow waived their ability to now argue that the plea should be vacated?
Well, they're still not arguing that the plea should be vacated.
Well, we'll hear from them now. Thank you.
No, they're not arguing that the plea should be.
Well, we're going to hear from them in a second. Let's wait.
Well, he hasn't.
Well, because you have to sit down so he can get up.
Good afternoon again, Your Honors. Michael Tarbutin for the People. Your Honors, the proper remedy here is to remand for plenary resentencing, which...
So do you agree or that we could simply resentence based upon the record before us?
You could, but that would be a mistake, Your Honors. If you're limiting the resentencing to the attempted murder sentences and not to the, to the murder one sentences.
Would you kindly lift up the microphone?
Sure.
Thank you.
This court has the authority to remand for plenary resentencing for resentencing on the attempted murder sentence, so the court the lower court can.
That was Justice Scarpulla's point, I think.
Right. And this court has done that in People versus Sergio Rodriguez and People versus Montel. That was affirmed by the Court of Appeals and the appeal of People versus Rodriguez. This court has the authority to remand for resentencing on legal sentences, in this case, the attempted murder sentence.
But we're beyond the illegality of the sentence because we're also talking about the additional, whatever the additional sentence would be.
Right. And even though that's a legal sentence, this court can remand for a restructuring of the sentence so that the motion court could, if it in its discretion, impose that.
Right. So your friend said that you stated at the 440 that you were not asking or moving for the plea to be vacated.
No, Your Honor. We're asking, certainly now we're asking this court to exercise the authority it has under 47020 to protect our rights, that's the language of the statute, to craft a remedy that not only rectifies the error and the prejudice against the defendant, but also to protect our rights by remanding for restructuring of the sentence.
And at the resentencing, both parties can put in evidence.
Yes, Your Honor.
Right, to figure out the new sentence. It's not just check off the box.
Right, it would be a plenary resentence and we could litigate the entire thing. And as to the case of People versus Anonymous that the defense relies upon, that case was different because it was the defense asking for the correction of an illegal sentence and then asking for more relief beyond what was necessary to have essentially a reduction of the sentence on the legal sentences. That wasn't the case where under 47020 we're asking this court to exercise its authority to grant us to protect our rights as well, which of course this court can do.
Thank you.
The cases that the prosecution has cited where this court has remanded for plenary resentence were cases that were judgment appeals. They were not appeals of denials of 44020 motions, which only deals with the illegality in a sentence. Their remedy was to below ask for the court to vacate the plea. Then they could have said, we're not offering X, we're offering Y. They could have done everything that was originally available to them to craft what they believed was a fair sentence. Instead, they're saying, we didn't do that. We're asking this court to go beyond what's before this court, which is really only the illegality.
No, can't we, why would it be beyond us to remand for resentencing?
Because we're not here on a judgment appeal. We're here on an appeal of a denial of a motion to correct an illegality in a sentence.
To set aside the sentence as it imposed consecutive rather than concurrent terms of incarceration.
Yes, only that particular thing. We didn't ask for a plenary resentencing. We didn't ask, as he's saying, the People and People v. Anonymous asked that this court denied for something bigger than that. We only asked to correct the illegality, and that's the only thing that was denied. Look, the court below went beyond what it was supposed to do, and it said if this court then reverses her denial, she was ordering that the sentence that was previously concurrent would automatically be triggered to be consecutive. That was beyond that court's authority.
But that's the whole point, because even if we did in fact rule that the sentences have to be concurrent as opposed to consecutive, you still have the issue in terms of the sentence on the other charge.
Well, it's not really an issue because it was a legal sentence and it's not a judgment appeal.
I don't know.
We would ask that this court only deal with what is before it, that this court not expand what it has done in every other case where the defense has asked on a 442.
Yeah, I do believe that there is a difference, though. But
There
you know,
is a difference
yeah.
because it's not a whole judgment appeal. We're not asking the court to review the whole case. We're asking the court. The legislature provides for CPL 44020.
No, I understand that, but in terms of resentencing, it could create other issues. But thank you both.
I do just want to say, in the event that this court does, which we are not asking, a plenary resentence, we would ask that it be directed not to go before that judge who clearly already made her determination that she would be ordering the other sentence to be consecutive.
Thank you. Last but not least, Allen v. Allen.
Good afternoon. May it please the court. Michael Cassell, Hogan and Cassell for the defendant, appellant Jeffrey Allen. He did obviously save the best for last. Yeah.
Counsel, I have a question. I think I've been on this court for almost 9 years, and my memory is that we've never reversed a pendente lite motion while I've been here, and that's because we apply the principle that the remedy for an inequitable pendente lite award, and I'm not saying that the award at issue was inequitable, but even if it were, the remedy is a prompt trial. So why do you think that in this case we would consider reversing the pendente lite award when we almost never do that?
Well, I'd submit for two reasons. First, there was a prior appeal that we brought up to this court, which in my understanding was a pendente lite decision. It barred my client's girlfriend from being allowed into the residence during the pendency of this action, and that was reversed by this court. So there's already been a prior appeal in this case that this court granted part of the appeal in my client's favor. And secondly, why I understand the pendente lite, idea, which is a speedy trial, the Supreme Court justice has already told us it's going to be years and years before we ever get to trial on this case. So under those circumstances, the mere fact that a court may at times say, well, your remedy is a speedy trial, it just simply doesn't apply here. There's no speedy trial in this case. It's not going to happen. And the relief that we seek here is specific. It precludes.
May I ask you, did the trial court say that because of the conduct of the litigants and the lawyers, or because the trial court felt like, oh, I have such a big counter? Because when I read that record, it seemed to me that the trial court was saying that not because the trial court couldn't do a quick trial, but because of how the parties were litigating the case.
I believe the trial court was telling the reality, which is it's going to take.
Which is the way you are litigating this case, I will not be able to get you to trial for quite a long time, correct? It's not like my docket is so full.
Well, I think the judge said that, number one, we need to finish discovery, which isn't finished. And number two, even when a note of issue was filed, irrespective of any claims that this case is taking longer than it is, which I don't know if it is, but more importantly, he made it very clear, even if after the note of issue is filed, the discovery is complete, we're just going to get in line and just wait and wait years before.
Was that in the context of saying, shouldn't you mediate this case and try and resolve it?
It was in that context.
Right.
But
It wasn't that, right. So sort of to say, oh, the trial judge says I'm never trying this case, that's not right. The trial judge was saying to you, gee, it's been 3 years and you haven't taken a single deposition. Gee, you're litigating this case like you were never going to get done with it. And gee, you should mediate the case. That's quite a different posture than what you're talking about now.
I understand that. If it doesn't change the fact that we have an order here, which I asked this court for the reasons we set forth in our brief to reverse. We set forth the reasons as to why the restraint on these 144 Pulaski should be reversed. And also, lastly, the second part, which I think is important as far as the order, the part that prevents my client from ever, he could win the lottery tomorrow, and under this order, he cannot put a single penny into these businesses. And just the last point, as far as
Counsel, just piggybacking on what my colleagues have said, the court urged the parties to sit down and try to work out even an interim partial stipulation so that matters could proceed here more quickly. I think you're hearing something from a few of us here, which is to say, consider how this is going and what could possibly be done to speed it up.
I understand that. It's not on the record, but we did go to mediation. It wasn't successful, but we did attend the mediation.
Thank you.
Thank you.
Good afternoon. May it please the court. John Teitler of the law firm of Teitler & Teitler on behalf of the plaintiff respondent Susan.
So is what your friend just stated correct, that even if he won the lottery, he could not deposit the funds into the that account?
What the automatic orders provide, both in this case and in every case, in that you are not allowed to make unilateral decisions with respect to transferring assets. It applies to both marital and separate property. I was on the matrimonial committee when the comments were made with respect to the statute when it was passed. There was a decision made rather than having Leibowitz injunction after Leibowitz injunction being submitted. Instead, the presumption would be flipped.
Right.
There would be an automatic order. And if you had a reason to come to the court, you could come and you could do one of two things. You could ask your spouse to consent, and if your spouse didn't consent, you could ask the court to lift. That did not happen here. Instead, we had the defendant engaging in self-help, and it's amazing that the appeal that he's referring to, that my learned colleague is referring to, is the Bacon appeal, where his client sought to unilaterally exclude our client, who's the daughter of a rabbi, from her home by cooking bacon in the kitchen. And they appealed that order, claiming that he had a First Amendment right to do that. Now that's the kind of, and I'm not to my counsel, but that is the type of litigant we are dealing with. On every matter, large and small, Justice Chesler has been faced, and if you, I know you probably didn't read through all of this, but you will see time and again, Mr. Allen refusing to listen to the court. The court has had to shut off his microphone, instruct him to shut off his microphone during Microsoft Teams. There is no doubt that in this case, and we can get into the substance, but my client, Susan Tish Allen, her entire adult life has been in the business of developing real estate, residential real estate. Her husband has been in the business as a concert promoter. He was not in the real estate business. During the course of their marriage, while he continued to be a talent agent and a concert promoter, our client introduced him to various projects. She is the one, and you can actually, Your Honors, I know my time is going to be up in a minute, but he himself admitted that it was Mrs. Allen. There's a quote in here, and I'll cite you to the record. Under oath in a litigation, not this one, in 2017, he specifically said that, quote, Mrs. Allen designs, conceives, and develops the homes. He has admitted both under oath and separately that she was the one that was doing this. This court had so much factual and legal authority to issue its order. There is no doubt that it was not an abuse of discretion. And by the way, this judge has not said, I don't believe, that it's going to be years and years before this case is tried. He's referring to statements that were made in 2022, coming right out of COVID, where the judge said, you really ought to settle this case, and you really ought to try to resolve these issues yourselves. And if you read that record, if you got to it, and I said, Your Honor, we would love to do that. That's what we want to do. We want to try to settle this case. We sought repeatedly to try to settle this case. It did go to mediation before Justice Gish. That's not in the record. Justice Gish said, let's keep going. We said, let's keep going. They said, no thanks. We want to go back to litigation. This is the orphan who killed his parents, not you, sir, your client. And what we have here is a situation where he has again and again on issues large and small litigated everything. He has tried Justice Chesler's patience. Justice Chesler has been a saint. Justice Chesler has said, perhaps I might have to appoint a receiver. Sir, if you continue this, I might have to put you in jail. And instead of us coming in and making those motions, we said, let's try to settle. So yes, a speedy trial would be the remedy here. If he would get out of his way, we might get to a speedy trial. The court recently said, we're going to wrap up discovery. The court might try it. It might go to a referee. But there's nothing in the record that suggests it's years and years. I could go on, but I don't know that
But
you
you
need
don't
to
have
hear
the
any
time.
more,
We ran out of time.
any more
Thank
from me.
you.
Thank you very much, Your Honors.
Respond to all that. First of all, the automatic orders, I don't disagree per se as to the scope of the automatic orders, but they apply to a snapshot as to what the parties have on the date of the commencement of the action, which is March of 2021. We have property here that the record shows was purchased a year after the commencement. It affects my client's ability to take monies that he earns. We're now 3.5 years post-commencement of this action.
Are you suggesting the automatic orders only affect the parties at the moment of commencement
I'm
and not throughout the litigation?
I'm saying the automatic orders, you take a snapshot of what the parties.
And it doesn't affect their conduct after the commencement of litigation?
It does, but it doesn't affect
just
a
wanted to make sure
situation where the monies at issue are monies that are my client receives a year post commencement of the act.
Counsel, you might reconsider scorched earth methodology. Maybe it would make a difference here.
Well, if I could just respond, as far as discovery, I mean, we went through the mediation for Mr. Tytler to imply to this court that the mediation fell apart because of my client is completely erroneous. It takes two sides to settle any case.
It takes two to tangle, but I think you're hearing something.
I understand.
Anything else, Counselor?
No, have a good evening. Thank you, Your Honors.
Thank you all.